came with one thing, right?
right? That's the one that did the girlfriend.
Yeah, we did the first trial with him, with Miss,
Where
Your-
he was
with
exonerated.
your second chair.
Karen.
Yeah, we
Carolyn.
did, yeah.
I forget who tried that with her, maybe Donna Perry.
It was down the Perry.
Yeah.
Mm-hmm.
If not, she'll let us know, if she's taking out the judges or we'll let the, this your case can have to go trial before trial. So, we will see what she's got available.
It was great.
It's not like it's an upper. Oh.
I don't know, I feel like he's Yeah, I don't really doubt it.
He helps you if I say, hey, I'm missing this.
Ah, okay.
And make a list of what you're missing.
Really?
He's honest and
Yeah.
like honesty.
Yeah.
And not measles. I think Van Heist is pretty honest. What he can and can't do.
Yeah.
I like Nightmare. He's me out in 2 cases. Happens on one side.
I feel like I have one actually fairly recently with my younger, with a similar issue, like he stopped me, no, it couldn't have been Kreiner. So I didn't have something, maybe it was, no, it wasn't. I think it was Albertson, but like he stopped the interview. Like he was, yeah,
I
like
believe it.
he,
I
like,
believe
you
it.
know, after talking to the
Yeah.
client, it's like, okay, you know, clearly not.
Yes,
With it.
that's him.
Either that or maybe they just talked to me.
True.
So I believe she did, I think that there was some disagreement among some of us as to whether it was today or yesterday that was supposed to be. I thought so, right? Yeah. No, no otherwise, we're early. We're early.
I've had JK on the way in.
Oh, really? Everything okay?
Do you need a bug anymore?
No.
I
Oh,
just do. Are you fully charged?
yeah, I don't,
Okay, let's not get in, get serious. Here we go.
Yeah, I feel like the later we go into
I mean, I don't know.
December, the tighter it gets.
Right. Yeah.
So I'd rather I'd rather the next week
And I know.
of December or
Oh.
November.
Okay.
I don't know what she has in November. Yeah, they do.
And I'll look real quick.
So I'm supposed to be out, well, like the Veterans Day on Wednesday, I'm supposed to be out
Okay.
12/13. So that makes it a little tight as far as either this week of the second or the week of the 16th.
So.
So all we're, let's run holidays.
I know, I know.
Or Christmas.
Thanksgiving.
Yeah.
Here for Thanksgiving week. Look, I'm not doing it anymore. It's like a week before school starts. That's a new one.
Oh,
There's no
really?
reunions.
Oh, really? What are you supposed to, yes, right, what are you supposed to do?
Wait, oh, family.
Right, yeah, I guess
Parents.
so.
Literally, so I'm like, going to the, when I had it this year.
Alright, so you said, so the week of the 9th is out for you, right?
It'd be,
Okay.
yeah, it'd be difficult.
Okay.
Very-
So then we're looking at the 16th, the 23rd is Thanksgiving, but that's obviously not what I know. So. The 16th.
All right.
16th.
Or the, no, or the one with
Well,
like 7 or 14. Yeah. And that's always.
Yeah, both those ones are good. I'd assume we don't really expect this to go a whole week, right? Because that week of 12/7, I have Disney planned for Friday. Disney Christmas trip. I was so excited yesterday. Yeah, we know where we're going.
You know where we're going.
I'll try and,
Yeah. So hopefully that will be it.
Yeah, you
hopefully maybe I'll try and.
All right, Kristen,
Yeah. Sooner rather than later, that would be lovely.
I'm sorry.
So I got into this
on your screen, but I'm keeping an eye out.
Right, so like every year I always forget and I'm too late to get the tickets because they sell out super quick. And then I put a reminder on my calendar this year, and they went on sale yesterday at 12, and it was like 12:30 and I looked and I was like, oh man, but I was like, oh yes, I got it. So that's
After like
really
4
exciting.
years, then it's more.
Yeah.
I'm sure you see more than you bargained for.
Not really. Not really.
Are you guys technically starting at 9?
I thought we were saying at 18.
Yes.
Oh, is that already on there? Thanks, okay.
She put a pad down like, this.
Thanks, where was that?
Okay.
Jury selection. Law. I think I already have it.
Rich, are they all here?
Scott and his PowerPoints.
In the center.
That's like yes. Yeah, that's like yes. Reggie,
I've never had it.
Rich,
Maybe.
Good morning, everyone.
remains to cover all the now session.
Morning, Judge.
Did everybody get the updated instructions?
Yes, Your Honor. Competency of
What am I looking at? Okay. All right, we have Aaron Morris on for a status, and those are two cases. One is a homicide and the other one is a drug offense, 26 CF 001395, 26 CF 010789. I have both Ms. Grajales and Ms. Dunker in here. What are we doing on these?
Morning, Your Honor, Maria Dunker on behalf of Mr. Morris. Speedy trial in this case does run on 12/31. It is the defense's intention to try this case within that time period.
Okay, well, here's what I'm gonna tell everybody. Ready?
Ready?
So, right now, I may become available, and there is gonna be, you want speedy trial, you're gonna pick the dates I can give everybody, just so that everybody knows. September 14th, or it's only, the next date is only a 4-day week, because there's a holiday on the 21st, or September 22nd. But I'm not gonna know if either of those weeks are for real until later today. I have currently a civil toxic mold case set to start on September 14th and go through the 25th, but they have filed a motion to continue. I've spoken to the docket division judge in there, Judge Polo. She hasn't seen the motion yet, She's gonna look at it and she's gonna let me know today if she's gonna continue it. If she is, one of those 2 weeks are the weeks I'm gonna set it. Okay, if she's not going to continue it, then let me double check one thing. Then, the only other week that I'm gonna have to bump a trial that I have set on December 7th. I'll find somebody else to try that case, and we will try Mr. Morris's case that date. But I am going to squeeze it in September, and I'll give you that option if that case is gonna continue, because I'd rather not bump a case they've been counting on me to try on December 7th. Okay?
You said that was either going to be the week of 9/14 or,
Or the the following week, because the following week, what everybody has to be aware of, that's a 4-day week, because that Monday's a court holiday.
I don't think that'll be a problem.
So either one of those. That's where I am gonna put it if that case gets continued.
Okay,
Okay, but otherwise I will put it on the week of December 7th.
okay. So will the court just let us know?
Yes, I'll let you, well, I'm gonna see you, but I'll let you all know via email the minute I hear from Judge Polo.
Okay, all right.
I'm reaching out to my detective, since obviously that is a little bit short notice. I've been talking to him about November and December, but make sure he's not, out of
Yeah,
town either
It's
of
just
those weeks.
we're packed. Now,
Understood, Judge?
something else may clear up, but I'm not gonna know. I don't see anything. I looked at all the pleadings and all the other cases that I've set from here until the end of the year, and everything else, I'm not seeing anything that indicates. Now, you can contact your brethren and see if any of these, so I can tell you right now, before we then go back to what we've gotta do with these jury instructions. I've got, Xavier Navarrete, set the week of October, 26th, that has Miss Beardsley and Miss Ojeda on it.
Okay.
It's out of Judge Alvarez's division, so you can contact them and see, hey, what do you think? Is it really gonna go? I have Brianna Moore out of, I think it's now Judge Kaiser's division. Used to be, I got it from Judge Palermo.
What week is that set,
That
Judge?
is set for 2 weeks, beginning November 2nd. And it's supposed to go through the 12th of the 13th. I have reached out to Ms. Hodges and Mr. Dickstein on that, because to me that looked like a potential plea case. But Ms. Hodges offered 20 years and they're not taking that. So that's where they are on that one. Then we have Schultz, co-defendant case, murder case, Schultz and Garcia, set the week of November 16th, and I think that's out of Division B, and I'll tell you who everybody is on that one. On one of the co-defendants, he's been getting multiple evaluations recently, and that is, that's out of Twine Thomas's division. I've got Elise Ronick and Danny Hernandez.
That's November 16th week, Judge?
That's November 16th, then on the 30th,
I think Ms. Baker's unavailable the week of the 30th.
November 30th?
mhm,
Yes, I'm in trial with.
Okay.
yes.
I've got Jamarcus Welch on that week. Then the 7th is the one I have the sex crime that I'll move or get somebody to do. And then I have the Angelo Cruz might be one that doesn't really go. And that has Mr. McClimate and I believe Mr. Gale on it. Let me take a look.
Is that the 14th?
That's the 14th. That's the last jury trial week of this year.
Yes, ma'am.
So you find another spot because you're aware of something that for sure isn't going to happen, and I'll do that. But I'm looking at. Oh no, I'm wrong. The Angelo Cruz is, and I know it's going to go because I remember Miss Spradley. It's Miss Spradley and Justin Diaz. Sorry.
Which week is that one?
That's D'Angelo Cruz, that's the week of December 14th. That's
Gotcha.
definitely gonna
Okay.
go unless they are reaching a resolution,
Yes, ma'am.
okay? All right, I'll keep you in the loop. I'll shoot everybody an email when I know more.
Thank you. Thank you.
So for now, here's what we're gonna do. We are going to set Mr. Morse for status this coming Monday, August 24th at 8:30 in the morning. That will not go. I will cancel it if I get told that the September dates are gonna free up.
Is there any way you'd be willing to do it the following day on the 25th, Judge?
Sure.
Just so that I can go to the jail and speak with Mr.
Yeah, not a
Lewis on that
problem.
Monday?
Not a problem. August 25th at 8:30 in the morning.
Okay, perfect.
Thank you.
Thank you.
Okay. Have a good one, everyone. Nice seeing you, Ms. Grajales.
You too as well.
Off the record, during that entire period of time, Mr. Banks was present in the courtroom, as were his lawyers and the lawyers for the state. We are going to do a run-through. I did receive Ms. Dunker's email this morning, and my assistant Susan made the changes that she had suggested in the instructions. So let's start. Everybody got sent those with the corrections on them. Any objections to final instructions 3.1?
No objection.
3.2 statement of the charge, which also includes the definitions which apply throughout these instructions. Any objections?
None.
7.1 introduction to homicide and attempted homicide. Any objections?
No objection. No, Your Honor.
7.2 murder in the first degree, count 1. Any objections?
No objection. No objection.
6.2 attempted first degree murder, first degree premeditated murder, which applies to counts 2 and 3. Any objections?
No objection. No.
Then we have 6.2 attempted first degree murder, premeditated murder of a law enforcement officer, which is charged in count 4. Any objections?
No objection. No objection.
Then we have our heat of passion instruction that we made. Any objections?
No objection. No
Then we have 3.4, lesser included crimes or attempts. Any objections?
No objection. No objection.
7.4, murder in the second degree, a lesser included offense of count 1. Any objections?
No objection. No objection.
7.7, manslaughter, a lesser included offense of count 1. Any objections?
No objection. Can we just remove the or in 2?
Let me look. Okay, good catch. Okay, let me look. All right, I did that. Anything else with 7.7 manslaughter or lesser of count 1?
No, nothing else.
All right, then we've got 6.4 attempted second degree murder, lesser included offense of counts 2 and 3. Any objections?
No objection. No objection.
Then we have 6.6 attempted manslaughter by act, lesser included offense of counts 2, 3, and 4. Any objections?
No objection. No objection.
Then we've got 8.4 aggravated battery, lesser included offense of counts 2 and 3. Any objections?
No objection. No objection.
Then we have 6.2 attempted second degree murder of a law enforcement officer, a lesser included offense of count 4. Any objections?
No objection. No objection.
Then we have 8.2 aggravated assault on a law enforcement officer, a lesser included offense of count 4. Any objection?
No objection. No objection.
I think we defined, can somebody go really quickly up to the definitions under statement of the charge?
Yes.
I think we defined a deadly weapon already, so I'm gonna eliminate that paragraph from 8.2.
Dangerous weapon. So we have dangerous weapon and then a weapon is defined.
All right, I'm gonna put deadly weapon over there. Is that okay with everyone?
Yes.
Let me go back up.
Come on. What's going on here?
Aggravated assault on a law enforcement officer. I removed the deadly weapon and put it up, the definition up in the definition sections. Any objections to that instruction?
No objection. No objection.
Okay, then we've got aggravated assault, another lesser of count 4. Any objections?
No objection. No objection.
All right, then we have 3.3A, carrying, displaying, using, threatening to use, or attempting to use a firearm or weapon. Any objections? I put the aggravated battery in there.
No objection. No objection.
3.3D, we also put the aggravated battery in that one. Any objections?
No objection.
3.7, plea of not guilty, reasonable doubt, and burden of proof. Any objections?
No objection. No objection.
3.9, weighing the evidence. Any objections?
No objection. No objection.
3.9B, defendant's statements. Any objections?
None, Your Honor. No objection.
3.12 verdict, any objections? All right, and then we've got the verdict form on pages 27 and 28, any objections? Actually, it's also goes 29, 30. The verdict form goes up to page 33. Any objections to the verdict form?
Just take them one little.
The only thing we removed from it, I don't like where it says, special finding form, because there isn't a separate form, so I just put special finding for count. We removed form there, but other than that, we didn't touch it.
Looks good, Judge. Yep, no objection.
Does it look okay? All right. 3.12, single defendant, multiple counts or informations, any objections?
Standard, Judge, no objection. No objection.
Same thing, closing argument, 2.7, any objections?
No objection.
Cautionary instruction,
No objection. No objection.
rules for deliberation,
Standard, no objection. No objection.
submitting the case to the jury.
No objection.
All right, perfect. I'm gonna ask her to print. We've got, let me ask everybody this. Once we're done, we're gonna talk to Mr. Harmon about any rebuttal, but once we're done with that, before I begin instructions, does anybody have an issue with me releasing the alternate? So they don't sit through the closings? Are you okay with it?
I'm fine with it, Judge.
No issue, and Judge, I think unless Mr. Harmon has an objection to it, we would like to substitute the alternate and make juror number 17, Ms. Hernandez, the alternate.
You okay with that? It's because she's the one that wants to go on the trip, she has the trip
Oh, yeah,
planned
yeah, yeah, yeah.
with her friends.
I was trying to, it doesn't sound right in my head the way you said it, but I
I'm
understand
sorry.
it now. To make her the alternate so we can
Yeah.
release her.
We
Yes,
can
Right.
release her, yeah.
Okay, so everybody's okay with that, both sides?
Yeah.
yes.
All right, so we will substitute alternate, the alternate, which is juror number 37, for juror number 17. Juror number 17 is now the alternate, and with everybody's approval, we will release her prior to jury instructions.
And Judge, I just reviewed that with Mr. Banks, and he agrees as well.
You're okay with that, Mr. Banks? Okay, and Mr. Banks, you've been here both yesterday when we were off the record going through all these jury instructions, correct, sir?
Yes, ma'am.
And this morning, when we've done our final run-through, you've been here, correct? All right, thank you.
Scott, I'm gonna take this down just for a quick second.
Yeah, yeah,
No,
yeah.
no,
Here.
I just want to test something out real quick.
Absolutely.
Thank you. Just want to make sure I'm not going to miss anything out.
Still planning on calling Detective Hill?
I am, Your Honor. I have him outside. He's going to testify specifically to, during the entire interview, from the beginning, his contact with the defendant until after the interview was over. He never threatened him, coerced him. He never raised his voice. They had a conversational tone.
Okay. All right, and then we're going to be ready to go into closings, correct?
Correct.
I'm going to instruct first, and then we'll do the closing. So, I don't remember, Ms. Dunker, did you rest in front of the jury?
I did, Judge, I did rest in front of the jury.
Okay.
I will just at this point in time then take the moment to review all of our prior motions and objections, including our motion for judgment of acquittal as to each of the counts.
All right, thank you. Your objections are all noted, same rulings. All right, let's bring in the jurors.
Do we want to dismiss,
Huh?
do we want to dismiss the?
Not right now. We haven't closed the case. And I don't have the instructions, so I may have to put them in the back again while we wait for them.
No, I did not.
Jury entering courtroom.
All right, the jurors are all in the courtroom. Everybody may be seated. Good morning, ladies and gentlemen. You know the question I'm going to ask. Between the time we saw each other last yesterday evening and this morning, did any of you do any of the things I have instructed you not to do? Have any of you seen or heard anything about this case from any source whatsoever other than what you've heard in this courtroom while we've been on the record? All right, perfect. Thank you. All right, so the defense rested. Does the state have any witnesses for rebuttal?
Yes, Your Honor. The state would call Detective Hill in rebuttal.
All right. Huh?
Right this way, Detective. You would stand right here. You're supposed to be sworn in.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do. Right this way.
Good morning. All right, Detective, you know the score with that microphone and how you got to talk directly into it and have it even with your mouth.
Yes, Your Honor.
All right, you may proceed, Mr. Herman.
Thank you, Your Honor. May it please the court. Good morning, sir.
Good morning.
Yesterday, you testified to an interview that you conducted with the defendant.
Yes.
From the point you made contact with the defendant till the time that you finished that interview, did you ever threaten the defendant?
No.
Did you ever coerce him in any way?
No.
Did you ever put any pressure on him?
No.
During that did you ever promise him anything?
I did not.
During that conversation that you had with him, that interview, what was the tone of the interview as far as the volume of your voice?
Very measured and generally low, the same as his throughout the entire interview and my interaction with him.
So a conversational tone would be a fair description?
Yes, it would.
Did you ever raise your voice?
No, I don't believe so.
We have one moment, Your Honor.
Sure.
I'll tender the witness.
Any cross?
I don't, thank you.
Thank you, Detective. Have a good one. State may call your next witness.
Your Honor, the state rests its rebuttal case.
All right, thank you. You have now heard all of the evidence you're gonna hear in this case. So, even though we just saw each other, I'm giving you a little opportunity to get your ups and downs in as exercise, because we are finalizing and getting printed the jury instructions. That's what we were doing before you came in this morning. We were finalizing the jury instructions. Now they're being printed. Remember what I told you all when you were potential jurors in the big panel on Monday? One thing most people leave here knowing is we're not spending our money over on this side of the courtroom, the courthouse. And so the printing is like we're back when we did things with an abacus, okay? So hopefully we'll have those in the next few minutes, but up until then, I'm gonna ask you to step in the back. Before you all leave, I'm going to release our alternate. Our alternate is juror number 17. And so I'm gonna ask you to stay seated while all your fellow jurors go in the back. Just so that everybody knows, we cannot try, we can, but it's not suggested that we try any trials without an alternate. Why? Because if the trial's gonna take multiple days, people have things that happen. People get sick, somebody in their family had an emergency, something arises. And if we don't have an alternate and that happens, we've gotta declare a mistrial and start all over again. So we try cases with alternates, and many, many times I put an alternate in the place because an emergency arose, something happened, a juror got sick, something happened with somebody in their family, something like that, and we have to use the alternates. Alternates are just as important as everybody else, and they're vital to our system, but they don't get to go back and deliberate, all right? So juror number 17, stay seated. Everybody else, please go in the back. The minute we have all your instructions, we will bring you back in.
Jury, I agree.
All right, the jurors have left the courtroom, the ones that are gonna deliberate at least. Everybody can be seated. I can't begin to thank you enough. Everything you heard me say when I did my portion of the jury selection on Monday, I feel with every fiber of my being. I believe in our country, our Constitution, all of those constitutional amendments, and we can't fulfill those promises as far as at least our judicial system without jurors such as yourself being willing to come in as a citizen and perform this really, really important constitutional civic duty. Now, if I were an alternate, I would be bummed that I didn't get to finish, okay? There's a reason why you are the alternate, okay? We don't know once they start deliberating if this may deliberate till tomorrow. It probably won't, but we don't know. And we know you have something planned that you and your friends and your children have looked forward to, and we don't want to interrupt that, okay? So just so that you know, that's why we're like, you're gonna be our alternate if the case doesn't start deliberating until Thursday, because we didn't want to do that to you. But I hope that you appreciate our position. I hope you appreciate your service. I hope that next time you get your summons, you'll understand the importance of it even more so than you did before you got here on Monday, and that you'll look forward to it as though a serious and a solemn responsibility, an important one, and one that you're willing to perform as you were today. So it's with the greatest thanks of me, all the parties in the courtroom, my fellow judges here on the 13th Judicial Circuit, that I release you from your jury service. I hope you have a great time doing whatever you're gonna be doing tomorrow. And good luck to you for the rest of this week and year. Take care of yourself. Thank you so much. Hey, by the way, all those rules I imposed on you, they're now lifted. Okay, take care. All right, so now we're just waiting for the instructions. The minute we get them, we'll bring the jury back in. Huh?
Another copy didn't come?
Huh?
Oh,
We're getting them printed. All right. Right, and we order it at 11 so that it's here when they retire. All right, we ready? Let's bring in the jury.
Unfortunately. See, check I was telling you about.
Yeah, I'm gonna need one for him too.
All right, the jurors are in the courtroom. Everybody may be seated. Okay, ladies and gentlemen, hot off the presses, you have instructions on each one of your seats. So let me talk to you a little bit about those instructions before I start reading to them to you. So I must, under the law, read these instructions to you. And so you have two options when I'm reading these instructions. You can either just sit back and listen, or you can follow along. I always find that we hear and read all our senses. We use it to learn, so you may want to read along while I'm reading these with you, but if you don't, just sit back and listen. These instructions will go back with you when you go to deliberate your verdict. You're going to be allowed to take your notes, and each one of your individual instructions. Now, before I begin reading them to you, let's turn to page 26. So on page 26 of each of your instructions and continuing through page 32 is a verdict form. So I have included a copy of the verdict form in each one of your instructions. There is a separate verdict form that the bailiff is going to give you when you go in the back to start deliberating. That's the one you fill out, the foreperson fills out and returns back to the courtroom when you have reached a verdict. I've included this instruction in each one of your packets so that you don't have to pass around one verdict form and be looking at it, and you can all discuss it while you're looking at the verdict form. But the separate one is the one that gets filled out, signed, and dated by the foreperson and brought back into the room when the jury has reached a verdict. So let's talk a little bit about the verdict form. So sometimes when I'm reading instructions, I'll look up and look at the jury. And sometimes I see the jury looking like I know my teachers thought I looked in math classes when I was in school. Math was not my deal, okay? And so when we were doing those, what I thought were complicated word problems, I always looked like, they were speaking Chinese and I didn't speak Chinese. So sometimes I look at jurors and that's how they're looking when I'm reading the instructions. So this is why I've started to do what I'm doing right now. When you look at the verdict form is like the test, and it has multiple choice tests, okay? You are armed, this is like an open book exam. You've sat, you've listened to the evidence, you've taken notes, okay? You have whatever notes you've taken along with your memories, okay, and your common sense. You're gonna have the instructions on the law. So between your memory of what the evidence is and what you believe the evidence is, you combine that with the law that I give you, and that helps you to answer these questions, okay? When you read what is being asked of you in the verdict form, all of the instructions are going to make sense. And I'll give you a for instance. If you look at the first question deals with count 1. Count 1 is the first degree premeditated murder charge, okay? So if you look at your options under count 1, the first option is the defendant is guilty of first degree murder as charged. But you'll see other options, okay? So there's an instruction I'm going to read to you that's called lesser included offenses. That's why between A, the defendant is guilty of first degree murder as charged, and D, the defendant is not guilty, there are two other choices. Those are two lessers. And you'll get told that even though the evidence may not establish that the crime charged was proven beyond a reasonable doubt, there may be lesser included crimes that you believe were proved beyond a reasonable doubt. So you consider those. And we'll go through those when I'm reading you the instructions. But this is just so that you all relax when I'm reading these instructions to you, because that information I'm giving you gives you the information along with the facts as you find them to be able to answer these questions, okay? So don't panic, it's all there, it's all gonna help you. If you make a selection, okay, of either A, as charged, or B or C, either of the lessers, okay, then there are additional questions that you've got to answer underneath that apply to possession of a firearm, whether injury was inflicted, discharge, and things like that, just so that you know. So when I'm reading you these instructions, now it's all going to go, okay, that's why she's given me these instructions. So with that being said, we can turn back to page 1, and I'm going to begin on page 1 to instruct you. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I'm about to give you. Page 2, statement of the charge. Michael Banks, the defendant in this case, has been accused of the crimes of murder in the first degree, attempted murder in the first degree, 2 counts of that, and attempted murder in the first degree of a law enforcement officer. And then underneath that, you'll see it says definitions which apply throughout these instructions. And so there are repetitive definitions. We've moved them all to the front so that I'm not having to repeat the same thing over and over to you as much as possible. And the definitions that are there are from the instructions. They are a definition for what a dangerous weapon is, what deadly force is, what great bodily harm is, what an intentional touching or striking means, a firearm is, deadly weapon is, a weapon is, an act, and what a law enforcement officer is. Those are all the definition for those terms. If you have a question when you read that term in an instruction and you want to see how it's defined, you look to that page. All right, on page 3, 7.1, Introduction to Homicide and Attempted Homicide. Michael Banks is accused of murder in the first degree in count 1 and attempted first degree murder in counts 2 and 3 and attempted first degree murder of a law enforcement officer in count 4. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. Attempted first degree murder includes the lesser crimes of attempted second degree murder and attempted manslaughter, all of which are forms of attempted homicide and all of which are unlawful. However, a killing or attempted killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find that Josephine Muentes was killed by Michael Banks, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the first degree, murder in the second degree, or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. If you find there was an attempted homicide of the victim by Michael Banks, you will then consider the circumstances surrounding the attempted homicide in deciding whether it was attempted first-degree murder or attempted second-degree murder or attempted manslaughter or any other lesser-included offense, or whether the attempted homicide was excusable or resulted from the justifiable use of deadly force. Justifiable homicide. The killing or attempted killing of a human being is justifiable homicide or attempted homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon Michael Banks or to commit a felony in any dwelling house in which Michael Banks was at the time of the killing or attempted killing. Excusable homicide. The killing or attempted killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing or attempted killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing is or attempted killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing or attempted killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing or attempted homicide is not done in a cruel or unusual manner. Next page, it continues. I will now instruct you on the circumstances that must be proved before Michael Banks may be found guilty of murder in the first degree, attempted murder, first degree murder, or any lesser included crime. Page 5, murder in the first degree, which is the crime that is charged in count 1. To prove the crime of first degree premeditated murder in count 1, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Josephine Muentes is dead. 2, the death was caused by the criminal act of Michael Banks. 3, there was a premeditated killing of Josephine Muentes. Killing with premeditation, in quotes, is killing after consciously deciding to do so. The decision must be present at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing, The period of time must be long enough to allow reflection by Michael Banks. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Page 6, 6.2, attempted first-degree premeditated murder, which is charged in counts 2 and 3. Count 2 involves Norma Banks. Count 3 involves Michaela Banks. To prove the crime of attempted first-degree premeditated murder in count 2 and count 3, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Michael Banks intended to commit the crime of first-degree premeditated murder. 2, Michael Banks committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. 3, Michael Banks failed to complete the first-degree premeditated murder. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. So, not to get confusing, but next, the law defines to you what would be necessary to prove the actual act of first-degree premeditated murder. Because remember, this is about an attempt, these 2, 3, and 4. So don't get confused. The only reason why that is in there is to show what would have needed to have occurred to commit a first-degree premeditated murder. We all are aware one didn't occur in counts 2, 3, and 4, okay? To prove that a first-degree premeditated murder had taken place, the state would have had to have proven the following 3 elements beyond a reasonable doubt. 1, that the victim was dead. 2, the death was caused by the criminal act of Michael Banks. 3, there was a premeditated killing of the victim. A premeditated killing, in quotes, is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by Michael Banks. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of Michael Banks convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Page 7. Attempted first-degree premeditated murder of a law enforcement officer, which is charged in count 4. To prove the crime of attempted first-degree premeditated murder in count 4, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Michael Banks intended to commit the crime of first-degree premeditated murder. 2, Michael Banks committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. 3, Michael Banks failed to complete the first-degree premeditated murder. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. Once again, you're going to see what would have had to have been proven to do the completed act of first-degree premeditated murder. To prove that a first-degree premeditated murder had taken place, the state would have had to have proven the following 3 elements beyond a reasonable doubt. Number one, Officer Darren Gibson is dead. 2, the death was caused by the criminal act of Michael Banks. 3, there was a premeditated killing of Officer Darren Gibson. A premeditated killing, in quotes, is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by Michael Banks. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convinced you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find Michael Banks guilty of attempted first-degree premeditated murder, you must then determine whether the state has further proven the following 3 elements beyond a reasonable doubt. 1, at the time Michael Banks committed the attempted first-degree premeditated murder, Officer Darren Gibson was a law enforcement officer. Continuing on page 8, 2, at the time Officer Darren Gibson was engaged in the lawful performance of a legal duty. And 3, at the time Michael Banks knew that Officer Darren Gibson was a law enforcement officer. Page 9, heat of passion. This applies to first-degree premeditated murder, attempted premeditated murder of a law enforcement officer, and the lesser-included crimes of second-degree murder, attempted second-degree murder, and attempted second-degree murder of a law enforcement officer. An issue in this case is whether Michael Banks did not act with a premeditated intent to kill, in parentheses, for premeditated murder or attempted premeditated murder, in parentheses, or did not have a depraved mind without regard for human life, in parentheses, the lesser included crimes of second-degree murder and attempted second-degree murder, in parentheses, because he acted in the heat of passion based on adequate provocation. To find that the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. And B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And C, there was not a reasonable amount of time for a reasonable person to cool off. And D, a reasonable person would not have cooled off before committing the act that caused death. And E, Michael Banks was in fact so provoked and did not cool off before he committed the act that caused or attempted the death of the victim. If you have a reasonable doubt about whether Michael Banks acted with a premeditated intent to kill or whether he had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should find him not guilty of first-degree premeditated murder or the lesser included offense of second-degree murder, attempted first-degree premeditated murder, or the lesser included crime of attempted second-degree murder. Page 10, when there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that Michael Banks committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if Michael Banks is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. The lesser crimes indicated in the definition of attempted first-degree murder, which are charged in counts 2 and 3, are attempted second-degree murder and attempted manslaughter by act, and aggravated battery. The lesser crimes indicated in the definition of attempted first-degree murder of a law enforcement officer, which is charged in count 4, are attempted second-degree murder of a law enforcement officer, attempted manslaughter by act, aggravated assault on a law enforcement officer, and aggravated assault. Page 11, murder in the second degree, which is a lesser included offense of count 1, which is the first degree murder charge. To prove the crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Josephine Muentes is dead. 2, the death was caused by the criminal act of Michael Banks. 3, there was an unlawful killing of the victim by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act is, in quotes, imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove that Michael Banks had an intent to cause death. Page 12, 7.7 manslaughter, which is another lesser included offense to count 1, which is the first-degree murder count. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Josephine Muentes is dead. 2, Michael Banks intentionally committed an act or acts that caused the death of the victim. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. Michael Banks cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that Michael Banks had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Page 13, attempted second-degree murder. This is a lesser included offense to the attempted first-degree murders that are charged in counts 2 and 3. To prove the crime of attempted second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Michael Banks intentionally committed an overt act that could have resulted in the death of the victim, but did not result in the victim's death. 2, the act was imminently dangerous to another and demonstrated a depraved mind without regard for human life. 3, the overt act went beyond mere preparation. An act is, in quotes, imminently dangerous to another and demonstrating a depraved mind, end quote, if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To convict Michael Banks of attempted second-degree murder, it is not necessary for the state to prove that he had an intent to cause death. Page 14, attempted manslaughter by act, which is another lesser included offense to the attempted first-degree murder charges that are charged in counts 2, 3, and 4. To prove the crime of attempted manslaughter by act, the state must prove the following 2 elements beyond a reasonable doubt. 1, Michael Banks intentionally committed an overt act that could have resulted in the death of the victim, but did not result in the victim's death. 2, the overt act went beyond mere preparation. Once again, the law defines what the difference is between an overt act and mere preparation. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. However, Michael Banks cannot be guilty of attempted manslaughter by committing a merely negligent act. Every person has a duty to act reasonably and use ordinary care toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. To convict of attempted manslaughter by act, it is not necessary for the state to prove that Michael Banks had an intent to cause death. Only an intent to commit an act that could have caused death and was not justifiable or excusable attempted homicide, as I have previously instructed you. Page 15, aggravated battery. This is a lesser included offense of counts 2 and 3. To prove the crime of aggravated battery, the state must prove the following 2 elements beyond a reasonable doubt. The first element is a definition of battery. 1, Michael Banks actually and intentionally touched or struck Norma Banks, she's the alleged victim in count 2, or Michaela Banks, she is the alleged victim in count 3, against her will. 2, Michael Banks, in committing the battery, A, intentionally or knowingly caused great bodily harm to Norma Banks in count 2, or Michaela Banks in count 3, or B, used a deadly weapon. Page 16. Attempted second-degree murder of a law enforcement officer. This is a lesser included offense of count 4. To prove the crime of attempted second-degree murder of a law enforcement officer, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Michael Banks intentionally committed an overt act that could have resulted in the death of the victim, but did not result in the victim's death. 2, the act was imminently dangerous to another and demonstrated a depraved mind without regard for human life. 3, the overt act went beyond mere preparation. An act is, in quotes, imminently dangerous to another and demonstrating a depraved mind, end quote, if it is an act or series of acts that, A, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. Once again, the law defines the difference between mere preparation and an overt act. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To convict Michael Banks of attempted second-degree murder of a law enforcement officer, it is not necessary for the state to prove that he had an intent to cause the death. If you find that Michael Banks guilty of attempted second-degree murder of a law enforcement officer, you must then determine whether the state has further proven the following 3 elements beyond a reasonable doubt. 1, at the time Michael Banks committed the attempted second-degree murder of a law enforcement officer, Officer Darren Gibson was a law enforcement officer. 2, at the time Officer Darren Gibson was engaged in the lawful performance of a legal duty. And 3, at that time Michael Banks knew that Officer Darren Gibson was a law enforcement officer. Page 17. Aggravated assault on a law enforcement officer, which is another lesser included offense of count 4. To prove the crime of aggravated assault, the state must prove the following 4 elements beyond a reasonable doubt. The first 3 elements define assault. 1. Michael Banks intentionally and unlawfully threatened, either by word or act, to do violence to Officer Darren Gibson. 2. At the time, Michael Banks appeared to have the ability to carry out that threat. 3. The act of Michael Banks created in the mind of Officer Darren Gibson a well-founded fear that violence was about to take place. And 4. The assault was made with a deadly weapon. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Officer Darren Gibson may be found to have been in fear, and actual fear on the part of Officer Darren Gibson need not be shown. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. It is not necessary for the state to prove that Michael Banks had an intent to kill. If you find Michael Banks guilty of aggravated assault on a law enforcement officer, you must then determine whether the state has further proven the following 3 elements beyond a reasonable doubt. 1. At the time Michael Banks committed the aggravated assault on a law enforcement officer, Officer Darren Gibson was a law enforcement officer. 2. At the time, Officer Darren Gibson was engaged in the lawful performance of a legal duty. 3. At the time, Michael Banks knew that Officer Darren Gibson was a law enforcement officer. Page 18, aggravated assault, which is another lesser included offense of count 4, the attempted first-degree murder on a law enforcement officer. To prove the crime of aggravated assault, the state must prove the following 4 elements beyond a reasonable doubt. The first 3 elements define assault. 1. Michael Banks intentionally and unlawfully threatened, either by word or act, to do violence to Officer Darren Gibson. 2. At the time, Michael Banks appeared to have the ability to carry out that threat. 3. The act of Michael Banks created in the mind of Officer Gibson a well-founded fear that violence was about to take place. 4. The assault was made with a deadly weapon. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Officer Darren Gibson may be found to have been in fear, and actual fear on the part of Officer Gibson need not be shown. It is not necessary for the state to prove that Michael Banks had an intent to kill. Page 19. Carrying, displaying, using, threatening to use, or attempting to use a firearm or weapon. So anytime you hear, if you find somebody guilty of X, okay, we just finished hearing, you must make the following findings. That's all pertaining to those following questions after each question on the verdict form as to whether or not you find the defendant guilty of the as charged count or lesser, okay? So if you find one of those, that's what these all apply to. You'll see the questions that follow after that on the verdict form. That's what this is pertaining to. If you find that Michael Banks committed first-degree premeditated murder, second-degree murder, manslaughter, attempted first-degree murder, attempted second-degree murder, attempted manslaughter by overt act, aggravated battery, or attempted first-degree murder of a law enforcement officer, you will then be asked to determine whether the state has proven beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a firearm or weapon. If you find that Michael Banks committed first-degree premeditated murder, second-degree murder, manslaughter, attempted first-degree murder, attempted second-degree murder, attempted manslaughter by overt act, aggravated battery, or attempted first-degree murder of a law enforcement officer, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm or weapon, then you should find him guilty only of first-degree premeditated murder, second-degree murder, manslaughter, attempted first-degree murder, attempted second-degree murder, attempted manslaughter by overt act, or attempted first-degree murder of a law enforcement officer. Once again, when we look at the verdict form, this is all going to make sense. Page 20, actual possession and discharge of a firearm. If you find that Michael Banks committed first-degree premeditated murder or second-degree murder, attempted first-degree murder, attempted second-degree murder, aggravated battery, attempted first-degree murder of a law enforcement officer, or attempted second-degree murder of a law enforcement officer, you will also be asked to determine whether the state proved beyond a reasonable doubt that during the course of committing that offense, he actually possessed a firearm and discharged a firearm. To actually possess, in quote, a firearm means that Michael Banks carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Page 21, plea of not guilty, reasonable doubt, and burden of proof. Michael Banks has entered a plea of not guilty. This means you must presume or believe that he is innocent. The presumption stays with Michael Banks as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome Mr. Banks's presumption of innocence, the state has the burden of proving the crime with which he is charged was committed and that he is the person who committed the crime. Mr. Banks is not required to present evidence or to prove anything. Whenever the words reasonable doubt, in quotes, are used, you must consider the following. Reasonable doubt is not proof beyond all doubt. A mere possible, speculative, imaginary, or forced doubt is not a reasonable doubt. Such a doubt is not a guess or mere conjecture. Rather, it is a doubt based upon reasoning and common sense after careful and impartial consideration of all the evidence in the case. A reasonable doubt as to the guilt of Mr. Banks may arise from the evidence, a conflict in the evidence, or the lack of evidence. If after a careful and impartial consideration of all of the evidence, you have a reasonable doubt as to the guilt of Michael Banks, it is your duty to find Mr. Banks not guilty. On the other hand, if after a careful and impartial consideration of all the evidence, you are convinced beyond a reasonable doubt that Michael Banks is guilty, it is your duty to find Mr. Banks guilty. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. Page 22, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which they testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other evidence and the other testimony in the case? 6, had any pressure or threat been used against a witness that affected the truth of the witness's testimony? 7, did the witness at some other time make a statement that is inconsistent with the testimony they gave in court? 8, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and the quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. Michael Banks has become a witness. You should apply the same rules to the consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for lawyers to talk to witnesses about what testimony the witnesses would give if called to the courtroom. A witness should not be discredited because they talk to the lawyer about their testimony. Next page, it continues. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Page 24, defendant's statements. A statement claimed to have been made by Michael Banks outside of court has been introduced into evidence. Such a statement should be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. If you conclude that Mr. Banks made the statement, you must also determine from the evidence whether his statement was freely and voluntarily made. In making this determination, you should consider the circumstances including, but not limited to, 1, whether when Mr. Banks made this statement, he had been threatened to get him to make the statement, and 2, whether anyone promised him anything to get him to make the statement. If you conclude that Mr. Banks made the out-of-court statement, but that it was not freely and voluntarily made, you should disregard it. Page 25, verdict. You may find Michael Banks guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned for each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you, and it is as follows. So, we begin on page 26. The top part, that's just called the style of the case. Okay, so we're going to begin with the first question. We, the jury, find as follows as to count 1, parentheses, check only A, B, C, or D. A, the defendant is guilty of first-degree murder as charged. B, the defendant is guilty of second-degree murder, a lesser included offense. C, the defendant is guilty of manslaughter, a lesser included offense. D, the defendant is not guilty. If you check either A or B or C, then you go down, okay? In addition to the verdict form, there are special findings for count 1. Once again, only if you check either A, B, or C. If you find the defendant of first-degree murder, guilty of first-degree murder or second-degree murder or manslaughter, you must then answer the following question. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? And there's a place for the jury to check either yes or no. If you find the defendant guilty of first-degree murder or second-degree murder, you must then answer the following questions. During the commission of the offense, did the defendant actually possess a firearm? And there's a place for you to check either yes or no. If you find the defendant guilty of first-degree murder or second-degree murder, you must then answer the following questions. During the commission of the offense, did the defendant actually discharge a firearm? And there's a place for you to check yes or no. If you find the defendant guilty of first-degree murder or second-degree murder, you must then answer the following questions. During the commission of the offense, did the defendant actually discharge a firearm and as a result of the discharge cause the death of another person? And there's a spot for you to check yes or no. Now we go to question 2. We, the jury, find as follows as to count 2, parentheses, Norma Banks. And then we have parentheses, check only A, B, C, D, or E. A, the defendant is guilty of attempted first-degree murder as charged. B, the defendant is guilty of attempted second-degree murder, a lesser included offense. C, the defendant is guilty of attempted manslaughter by act, a lesser included offense. D, the defendant is guilty of aggravated battery, a lesser included offense. E, the defendant is not guilty. So once again, you follow along. If, in addition to the verdict form, there are special findings for count 2, if you find the defendant guilty of attempted first-degree murder, attempted second-degree murder, attempted manslaughter, or aggravated battery, you must then answer the following question. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? And there's a place for you to check yes or no. If you find the defendant guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery, you must then answer the following question. During the commission of the offense, did the defendant actually possess a firearm? And there's a place for you to check either yes or no. If you find the defendant guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery, you must then answer the following question. During the commission of the offense, did the defendant actually discharge a firearm? And there's a place for you to check yes or no. If you find the defendant guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery, you must then answer the following question. During the commission of the offense, did the defendant actually discharge a firearm and, as a result of the discharge, inflict great bodily harm to another person? Then we go to the third question. We, the jury, find as follows as to count 3. This is the attempted first-degree murder involving Michaela Banks as the alleged victim. Check only A, B, C, D, or E. A, the defendant is guilty of attempted first-degree murder as charged. B, the defendant is guilty of attempted second-degree murder, a lesser included offense. C, the defendant is guilty of attempted manslaughter by act, a lesser included offense. D, the defendant is guilty of aggravated battery, a lesser included offense. And E, the defendant is not guilty. Once again, in addition to the verdict form, there are special findings for count 3 that only apply if you checked either A, B, C, or D. All right? If you find the defendant guilty of attempted first-degree murder, attempted second-degree murder, attempted manslaughter, or aggravated battery, you must then answer the following question. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? And there's a spot for yes or no. If you find the defendant guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery, you must then answer the following question. During the commission of the offense, did the defendant actually possess a firearm? And there's a place for you to check either yes or no. And then if we go underneath there, once again, if you checked either attempted first-degree murder or attempted second-degree murder or aggravated battery, you must then answer during the commission of the offense, did the defendant actually discharge a firearm? And there's a place for you to check either yes or no. And then once again, if you found the defendant either guilty of attempted first-degree murder, attempted second-degree murder, or aggravated battery, during the commission of the offense, did the defendant actually discharge a firearm, and as a result of the discharge, inflict great bodily harm to another person? And there's a spot for you to check yes or no. We, the jury, find as follows as to count 4. Check only A, B, C, D, E, or F. A, the defendant is guilty of attempted first-degree murder of a law enforcement officer as charged. B, the defendant is guilty of attempted second-degree murder of a law enforcement officer, which is a lesser included offense. C, the defendant is guilty of attempted manslaughter by act, another lesser included offense. D, the defendant is guilty of aggravated assault on a law enforcement officer, a lesser included offense. E, the defendant is guilty of aggravated assault, another lesser included offense. And F, the defendant is not guilty. In addition to the verdict form, there are special findings for count 4, obviously, if you check any of the ones that pertain, okay? If you find the defendant guilty of attempted first-degree murder of a law enforcement officer, attempted second-degree murder of a law enforcement officer, or attempted manslaughter by act. Hold on one second, let me double check something. Okay, or attempted manslaughter by act, you must answer the following question. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? And there's a place for you to check yes or no. If you find the defendant guilty of attempted first-degree murder of a law enforcement officer or attempted second-degree murder of a law enforcement officer, you must then answer the following question. During the commission of the offense, did the defendant actually possess a firearm? And there's a place for you to check either yes or no. Next, if you find the defendant guilty of any of those three, attempted first-degree murder of a law enforcement officer, or actually it's two, or attempted second-degree murder of a law enforcement officer, you must then answer the following question. During the commission of the offense, did the defendant actually discharge the firearm? And then there's a spot for you to check yes or no. Next, if you find the defendant guilty of attempted first-degree murder of a law enforcement officer or attempted second-degree murder of a law enforcement officer, you must then answer, at the time Michael Banks committed the offense, was Officer Darren Gibson a law enforcement officer? And there's a spot for you to check yes or no. Next, at the time Michael Banks committed the offense, was Officer Darren Gibson engaged in the lawful performance of a legal duty? And there's a spot for you to check yes or no. And then next, at the time Michael Banks committed the offense, did he know that Officer Darren was a law enforcement officer? And there's a spot for you to check yes or no. And then, so say we all dated, the foreperson fills in the date of August 2026, and there's a place for the foreperson to sign their name and a place for the foreperson to print their name. Next, page 33. Single defendant, multiple counts or informations. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. 34, closing argument. Both the state and the defense have now rested their case. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing arguments. All right, so when we pick up after closings, we're going to pick up on page 35. With that being said, is the state prepared to make a closing argument?
Yes, Your Honor.
You may proceed.
May it please the court. She never saw it coming. She never knew what hit her. Josephine Muentes never saw it coming. The only thing in that woman's mind that morning or that early afternoon was to go into the kitchen and have a cup of coffee. A cup of coffee with her longtime friend, her roommate, Norma Banks. She had no idea that within moments this defendant would come around the corner and snatch her life. How could she know what was about to happen to her? How could she know that the simple act of heating up some water in a microwave oven would be the last thing that this poor woman would do in her 52 years of life on this planet? The last thing. And in that instant, motivated by his murderous intent, because he got mad, because he was upset, he was pissed off, because Norma Banks was taking the object of his affections away from him. motivated by that anger and by his perverted desires for his own daughter. He comes around the corner and at close range puts a 44 caliber revolver to this woman's head and sends a bullet through her brain. Miss Moentez never knew what hit her. But she did. She knew what hit her because she got to watch as this defendant slaughtered her friend, put a bullet into her head. She got to watch as her friend fell to the ground. And she saw all the smoke from that black powder revolver filling that kitchen. And then this woman had to look down the barrel of that same gun as it was leveled at her face. And how do we know that? Because of the stippling, the tattooing that she will wear for the rest of her life. Tattooing, she told you, that has not left her face. She has tattooing. Dr. McKinnon told you there will at least be scarring on her face for the rest of her life. But she got to look down the barrel of that revolver. She had to have been in absolute shock at that point. The terror that she must have felt as that gun is discharged, the same gun that she just saw drop her friend. And that bullet courses past her eye, across her left head, cutting through her ear that had to be stitched into that cabinet behind her. And then this woman ran. She ran for her life as fast as she could at her age. She ran as this defendant followed her, firing into the wall right as she passed through that threshold into that living area at head level for her. At head level for her. And as she ran through that back room and ran to the back door, this defendant, her own son, trying to kill her, fires another round that hits that door right in front of her, either as she's getting ready to open it or as she's closing it or trying to. This defendant fires another round. She is hit in the head a second time. 2 bullets, 2 separate impacts, 2 separate places are struck on her head. She's struck in the head twice by bullets, 44 caliber bullets fired by that defendant. And somehow, miraculously, they did not enter the cranial vault of her head. And she survived. And she got away with her life. But 2 rounds to her head and a single round to Josephine Moentez's head and a bullet at head level as she went through that door. This defendant was shooting to get headshots. He had just seen the effect of one headshot, instant incapacitation, dropped the person he intended to murder, dropped her like that, and he was trying to do it to his own mother. 3 headshots on a moving target. Shooting a handgun is not an easy task. That's why those officers either grabbed their rifles or, in Officer Gibson's case, went back to his trunk to get his rifle. Remember what I asked him? It provides 3 points of contact. Not just holding it out in front of you like a handgun, but allowing a stock to go into your shoulder and then both your hands. 3 points, more stable, easier to fire, easier to hit your target with. This defendant gets 3 headshots. That's not happenstance, folks. That's premeditation. That's thoughtful, deliberate aiming. And that's exactly what he was doing. This is what he told Detective Hill. I aimed at my mother. He says from her chest to her head, he aimed at her head, just like he did Josephine Moentez. Instant effect. Neurogenic shock, Dr. McKinnon told us. And then Michaela Banks, 17 years old, a senior in high school, a time that most kids her age, they're celebrating, they're excited. School's almost over, they're about ready to move on with their life, move into either college or start working and into a career. An exciting time for most folks. This defendant's own daughter, caged in a bathroom, caged behind a locked door after she heard the gunfire, after she heard the commotion, and sent those text messages, or sent that text message to her boyfriend. Her boyfriend who lived in Pennsylvania, not some boy at Brandon High School. This girl wasn't pregnant. Her boyfriend, who she called Babe, her boyfriend in Pennsylvania. I heard gunshots. I'm in the shower. Please just be me overthinking. But of course we know it wasn't her overthinking. She heard footsteps come down that hallway and go into the room where we know the loading supplies are for that revolver. And what is she doing in that bathroom? Soaking wet. She's leaning against that door with everything she has down low in a crab-like stance, trying to defend herself. And then her father comes to the door and tries to get through the door, tries to push through the door. And maybe he fires first, but she describes for us all a sound. The sound of that muzzle, this muzzle of that revolver, this muzzle going against wood, going against that door as the defendant tries to find her head. Remember what she said? It sounded like he was dragging the tip of the revolver across the door, trying to find where my head was. Head wounds. Josephine Muentes and her grandmother. How intuitive of this young lady and her testimony. Trying to find her head. And when he couldn't find her head, it didn't stop this defendant. He fired straight through the center of the door. Straight through the center. Hoping to hit her, his daughter, in the center mass or in her stomach, somewhere where it would cause her to die. And when he still couldn't get through the door, then the problem solving starts. Thinking, problem solving. Puts the gun up to the lock and shoots and leaves that sooting, the same kind of sooting that was around the wound on Josephine Muentes' head, and blows that lock open and gets in the door and tries to grab his daughter, who's wet and slippery, and she's able to get by him. Somehow, again, miraculously, that round through the center of that door didn't hit this girl. She was down low enough in her crab position trying to press that door in that it didn't hit her. But not by any lack of effort on this defendant's part. And then she was able to escape that house, running out of that house.
I hear screaming coming from inside the house. Come over there. What's he at? He's in the house.
And then she had to come here and testify and see this video of all of this happening again. Look at the blood streaming down her leg, because she did escape with her life, but as you heard the evidence, not before suffering a gunshot wound at the hands of her own father, leaving a .44 caliber chunk of lead in her upper leg. Actually, 2 gunshot wounds. One went through above her hip and then into her leg. A round that she will carry with her the rest of her life. And every single time she tries to go upstairs, or every single time she goes for a long walk, or bends over, she's going to feel the pain that reminds her of this. Look at her. She'll carry this with her. And then we come to Officer Gibson. Officer Pearson and Officer Gibson are approaching that house. They are dealing with an active shooter. They're going to the threat, like they're trained to do, to confront him, to end it, to stop him. They already know someone has been shot.
Hey, let me see your hands! Let me see your hands! He's got a black jacket, he just ran back.
Look in the upper left-hand corner. That's Officer Pearson. This is Officer Gibson's body-worn camera. He is standing on top of that garbage can, exposing himself to fire so he can get a look at this active shooter. He's basically a law enforcement billboard. He has a uniform on. He is sitting there out in the open. And that defendant sees him, and we know it because he tells Officer Hill, Detective Hill, in his interview, that he heard someone yelling at him. Whether he heard him yelling, put your hands up or not, or whether he told Detective Hill that, we know he heard it. He heard it. But in addition to hearing him yelling at him, did you hear all that in the background? Did you hear the sirens approaching, getting close? Did you hear the horn and the noise of the big fire trucks coming down Lineball? All of that noise, and these officers are starting to swarm this area, but all those sirens, this defendant knew law enforcement was in front of that house. There's no doubt about it. He knew these were police officers. And to suggest otherwise flies in the face of this evidence. Anyone would have known by that point. And you see Officer Pearson again in the body-worn camera. Officer Gibson, is there any mistaking the fact that that is a police officer? Whether he has a microphone over the C or maybe the P is slightly covered on the front of a vest. That's a tactical vest covered in police officer gear. That is a police officer, and there is no doubt about that. Now, in all due respect to Officer Darren Gibson, who left his contacts in all night, every one of us sitting here can see how transparent that is, especially in the broad daylight of 12:47 p.m., the middle of the day, the most well-lighted time of the day, even in the middle of the winter, even in January. By 4 o'clock, 5 o'clock, the sun's going to set between 5:30 and 6 this time of year. Everyone knows that, and you're going to have harsh shadows. You can look at crime scene photos if you want. The only point we were trying to make is just remember, that was during twilight. This is the middle of the day. And you can clearly see in this photograph, you can see the bottom of this tree. You can see the ground, the wall, where it contacts the ground and the extension of the wall. That's from the body-worn camera of Officer Pearson just a minute or two before the shooting itself happens. A minute, a little less, a little more than a minute before the actual shooting. And that's where Officer Gibson is standing, just a little further back. Officer Gibson tells you, I clearly saw an individual. They raised what appeared to be a gun and fired at me. This defendant tells Detective Hill, I saw an officer in the front yard on the property line, which is exactly where Officer Gibson was standing. And I fired at him twice. Officer Gibson's body-worn camera. Running to the threat. Sirens approaching. More than one.
He's in the house.
Open mics, open radios that are being picked up by that body-worn camera mic.
And also there's another victim in the house. I'll note if they're conscious or not.
The sound of trucks, the fire trucks. Is Officer Pearson whispering that? He's yelling that at the top of his lungs.
Where's that? Yo, Jack, he just ran back in the house.
Officer Gibson is retreating south as he is firing. That's why those bullets go through the PVC fence. Just on the other side, right there. And then they go through the wood. That's not because he's standing down there. He shows him where he's standing, looking right through that transparent material over that chain link fence, which incidentally, even in this photograph, you can see through it. You can see the bottom of that tree extending down. And of course, the defendant tells Detective Hill, I'm a good shot. I'm a straight shot. I shoot straight. I shoot good. Detective Hill tells us. And look at the placement of those shots. Look at the upper marker. He is shooting straight where? Head level. Head level. Another headshot. With a cocked .44 caliber revolver. He is shooting straight down the middle, parallel to the house, very accurately. Thank goodness Officer Gibson had his training and knew to, quote, get off the X and start going south and moving as he's firing, moving and shooting as he's trained to do. If he had stood there, who knows what would have happened. Another miracle in this evidence. And you can see him heading south. And then we see these photographs. This was the beginning. This was the exterior of the crime scene. The first photographs, and you can already see the deep shadows of the sinking sun at that point. Now, what I would tell you about the defendant, and I'll talk about this a little bit later, keep this in your mind. He goes outside, all these sirens going, and this defendant, he's now murdered Josephine Moentes, attempted to murder his mother, attempted to murder his daughter, and he goes outside, hearing all the sirens. A police officer yells at him, he ducks back around. He ducks back around out of view from the police officer. Does he go inside and seek cover? No, he doesn't go inside and seek cover. He comes right back out and fires rounds, 2 rounds at Officer Gibson. Think about that. Why? Why would he come back out with all the sirens, already knowing he got yelled at by a uniformed officer to show him his hands? That's intent. That's intent. Officer Breacha. Two rounds fired.
Anyone there?
There was shots fired by a unit or the suspect?
Yes, 236. You shot 2 rounds at me and I shot back.
That's Officer Gibson. Soon as dispatch asks, right after those shots are fired through the front window, the defendant now is at the front of the residence. As soon as they ask, Officer Gibson comes back immediately. He shot 2 rounds at me and I shot back. There's 2 rounds in that chain link fence cover. The defendant tells Detective Hill he shot 2 rounds. Is there any doubt that this defendant attempted to murder Officer Gibson and knew he was a police officer? Absolutely not. And again, and I'll talk about this in a few minutes when I'm talking about premeditation, this is a single action revolver. That means the first time he fires that potential headshot through the middle upper part of that fence, he's got to reach up and cock the hammer again. He's either got to cock it or fan it and cock it and fire again. And he's able to do that fairly quickly, but it still requires him to cock the hammer, which takes more thoughtful action. Listen to these shots being fired out the front window. Those are about 2 seconds apart, 3 seconds apart. He's able to reach up and cock the hammer. If you listen closely, you can hear yelling from within the residence right before those shots are fired. He's yelling. He's the only one in there alive. Josephine Muentes is on her back, either dead or dying.
Anyone
There was shots fired by a unit or the suspect?
Yes, 236. You shot 2 rounds at me and I shot back. Shit, someone works here. What's up in the door?
He just yelled at them, "You did a bunch of fucked up shit to me, man," out the front door to these police officers. And remember what he told Detective Hill? I knew there were police officers out front, and I fired through the window. What did Detective Hill tell you in his testimony? He said the defendant told him, I fired out there, I knew there were police officers out there. I wasn't firing at any particular one of them. Detective Hill tells you that. Detective Hill's not trying to skew anything this defendant told him. He gives that testimony. How does that help the prosecution? How does that help our case? That he's firing through the front window at no particular officer. It doesn't hurt our case. We're not charging him with anything in that shooting because he didn't hit anyone. And he didn't hit anyone, and he wasn't firing at anyone in particular because unlike Officer Gibson, who stood and faced a threat in the open, standing out in the middle of the neighbor's yard in broad daylight so that he could take the active shooter out and expose himself like Officer Pearson did to death, to potential death, and it's only by the grace of God he didn't catch a bullet because he was trained to move off the X. These officers that he's firing at now are hiding behind these cars, and I don't fault them for that. There's already been an officer-involved shooting. This is a dangerous suspect, an active shooter. They have taken cover behind these cars, but he knows they're out there because he knows all law enforcement is there because of all the sirens, and now there's aviation over the top of him, helicopter flying around. And he's yelling at them. You've been fucking with me since I was a kid. You're going to hear this next. Let me just go back and play that for you one more time.
Fucking with you since I was a kid. Throw your hands up. He just opened.
So twice he opens the front door, according to Officer Breacha. The first time you did a bunch of effed up shit to me, man, and the second time you've been effing with me since I was a kid. Yeah, the 3-time convicted felon sitting over here, yelling at these police officers and showing you in this evidence his intent towards law enforcement. The same intent that he showed towards Officer Gibson just a minute before this. Just a minute and a half. Look at the time on there. 12:52:07. The shooting at Officer Gibson was 12:50:39. A minute and a half before that. You don't need to guess at his intent. He's telling it to you right here.
Open the front door and screamed and close it again. See your hands! Let me see your hands! Show your hands! Step out! Come out the door! Come out the door! Stand up and come out the door! Down on the ground now! Down on the ground!
And of course, he comes out. He's thoughtful enough to leave the gun inside. He knows he's got to surrender. He doesn't want to have it in his hand because he doesn't want to get shot. He leaves it inside. He comes out obeying and doing exactly what these officers tell him to do. The 2 rounds he puts through the front window, very close together, very well aimed, again at about head height.
Were you the one shooting? Yes? Who else in the house? There was another person in there, a roommate.
There's another person in there, a roommate. Remember what he told Detective Hill about Josephine Muentes? She was just there. She was just there. So I'm going to talk to you about the law as it deals with premeditated murder. You may remember these are the same slides from jury selection. But I'm actually going to start with the packet of instructions that each of you will have with you when you go back there. And this is in the instructions. Those slides are verbatim. So I'm going to kind of walk through this with you. I'll get to premeditation here in a minute. This is a definition section that Judge Gowdy read to you in the very beginning that applies to your deliberations. And I wanted to talk to you about a firearm because you're going to have to make findings of a firearm. And you've heard testimony that this is a newly manufactured, Italian-made revolver that is based on a design from the 1800s, the Colt Navy revolver. And it is a muzzle-loading black powder gun. Now, the defendant got up here and said it's an antique, all right? This gun is not something you buy in an antique shop. This was a newly manufactured firearm. The court will tell you the term firearm does not include an antique unless the antique firearm is used in the commission of a crime. So even if it is an antique, even if you want to believe what the defendant is telling you, if he uses it in the commission of a crime like murder and attempted murder of his mom, attempted murder of his daughter, attempted murder of a police officer, then it is considered to be a firearm. In making your determinations, and this will be repeated in the premeditated instruction, if you find she was killed by Mr. Banks, Ms. Muentes, you then consider the circumstances surrounding the killing, all right? So you're going to be looking to the circumstances of the killing and the behavior and the conduct of the accused. We'll talk about that in more detail. But one thing I want to cover with you very quickly, justifiable homicide, that's self-defense. This isn't self-defense, and that's very clear. Excusable homicide, not something many people hear commonly. So I want to walk you through that real quick. The killing or attempted killing of a human being is excusable and unlawful. It is lawful under the following three circumstances. Every one of these requires that the killing be committed by accident and misfortune, accident and misfortune, accident and misfortune. None of these apply. This is not an accidental shooting. These are all intentional shootings, the attempted murders and the murder of Ms. Muentes. None of these are accidental, but this is the way it reads. A killing or attempted killing committed by accident and misfortune, and doing a lawful act, which he wasn't, with usual ordinary caution, which he wasn't, with unlawful intent, without any unlawful intent, and he was actually off acting with unlawful intent. Occurs by accident, misfortune, in the heat of passion, upon any sudden insufficient provocation. Again, this isn't by accident and misfortune, so that does not apply. But there is a separate instruction on heat of passion, which I will talk to you about in a few minutes. When the killing or attempted killing is committed by accident and misfortune resulting from a sudden combat, there was no sudden combat in this case. Ms. Muentes was making coffee, not throwing punches. The defendant's mother was standing there in shock when he shot her in the face or in the head, hitting her face with that powder, the burning powder, and chasing her out of the house. And Michaela Banks was simply trying to get away. Murder in the first degree. This is what we have to prove to you, folks. Ms. Muentes is dead. She's dead. No doubt about that. The death was caused by the defendant. No doubt about that. The premeditated killing of Josephine Muentes. There was a premeditated killing. And now we can go back to our slides, which are a little bigger. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. However, the law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant, Michael Banks. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence, obviously. It will be sufficient proof of premeditation. Again, here we see the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. The only part of the instruction I did not read to you is the last paragraph, which says if you have a reasonable doubt about whether Mr. Banks had a premeditated intent to kill because he acted in the heat of passion based on adequate provocation, you should find him not guilty of first-degree premeditated murder. So, I want to talk to you about the facts of this case and how it demonstrates to you premeditated murder and premeditated attempted murder. Because in the facts, the first thing that demonstrates premeditation is the weapon itself. The weapon itself. And that's why the state went to such pains of having this explained to you, you need to look at the starting place here. He gets upset, he gets mad, he gets pissed off. And he tells Detective Hill, he tells you, he went and retrieved his firearm, which was unloaded. Which means he had to walk down the hall and he had to go into a room where that firearm was. It was either in the living room or it was in his son Jaden's room, Michaela's younger brother. So he had to go retrieve the firearm wherever he kept it. It wasn't in a holster on his hip, folks. So he had to go get that unloaded firearm. And then he had to get the loading supplies, which unlike the AR-15 that you saw these officers pulling out of the back of their trunks and charging with a charging handle that had a loaded box magazine inside of it, this requires multiple pieces and parts. He had to get the lead balls, which were in a bag. He had to get powder, which was in that copper powder flask. He had to get the small measuring device, and he had to get percussion caps. Now, they may have all been in the same location, but he had to collect them all and put them where he was going to load the gun. And then he had to go through the loading process, which I'm going to ask if you could just bear with me. I'm going to walk you through the loading process of this firearm. I've written it out. I'm going to read it to you. I'm not going to do it. I'll be talking, so it's going to go faster than if a person was actually doing it, but I'm going to walk you through it. This very detailed, laborious, multiple-step process that will demonstrate to you the deliberation and the thoughtfulness of loading this gun. So the first thing he has to do is pour powder from the flask into the measuring device, the 25 grains of powder. He's got to pour that into the measuring device, and then he has to hold the gun upright, and he's got to pour the powder. You see it in that first slide. Let me see if I can find it real quick. It's going to be in the upper left. That's a little bit different looking than the one the defendant had. His was a straight little device. He has to pour powder into that small brass tube, measure it, then he's got to hold the gun upright and he's got to pour it into the first chamber. Then he has to rotate it to the next chamber. Then he's got to pour more powder from the powder flask into that measuring device and make sure it's at the top. Then he's got to carefully pour it into the next chamber. That's 2. Then he's got to rotate it. Then he's got to take the powder out of the flask, pour it into that tube, make sure it's at the top, place it carefully into that chamber, pour it in there, rotate it. That's 3 chambers. Now he's got to take the flask. He's got to pour the powder into the small measuring brass container, make sure it's level, pour it into the chamber. Then he's got to rotate it. That's 3. Now he's up to 4. He's got to do the same thing, pour the powder out of the flask into the measuring device and pour it into the chamber. 4? 5. I'm at 5, okay. And then turn the carriage and then pour the powder into the measuring device and pour it into the 6th chamber. Now, after conducting that, he has to hold it upright so he doesn't spill it. And he has to grab a lead ball and place it into the 1st chamber, then rotate it. Then grab another lead ball, reach for it, pick it up, put it into the chamber, and rotate it. Then he's got to pick up another lead ball and put it to the chamber and rotate it. That's 3. Then he's got to pick up a lead ball, put it into the chamber, rotate it. That's 4. Then he's got to pick up a lead ball, put it into the chamber, rotate it. That's 5. And pick up a lead ball, put it into the 6th chamber. Once he's done that, then he goes to the cranking mechanism, this part, and he has to crank the press down, pushing that cranking bar on the top into the chamber, pressing the ball down onto the powder. He's got to lift the press back up. He's got to rotate it. He's got to press down. That's going to push down on the 2nd chamber. Then he's got to lift up rotate. He's got to press down again. That's the third chamber being pressed down. Then he's got to lift up, rotate again. That's the fourth chamber. Rotate, lift back up, press down on the fifth chamber, rotate, lift back up. And now in the sixth chamber, press and rotate. But we're not done yet, because now he has to place the percussion cap on the rear of the carriage onto the nipple or protrusion that sticks out. So he's got to pick up or find his percussion caps, take one, stick it over the nipple, and press it in. Rotate it. Pick up another percussion cap, place it over the nipple, press it on, rotate it. Pick up another percussion cap, stick it on the third chamber, rotate it. Pick up another percussion cap, place it onto the nipple or protrusion, that's the fourth, rotate it. Pick up another one, put it on the fifth chamber, press it in, rotate. Pick up the sixth percussion cap, press it in, make sure it's on there, and rotate it. So now he has a loaded firearm. Those are the steps he has to go through to load that firearm. This is an antiquated weapon. It's a deadly weapon, as we saw. It's a dangerous weapon. But that weapon alone, the loading of that weapon alone, is enough premeditation to convict this defendant all day long. You could throw out almost every other piece of evidence in this case. This weapon alone tells you that these were premeditated murders, a murder and attempted murders. Then he has to cock the hammer on the firearm. He's got to go from that room, walk down the hallway, go around the corner, and he encounters Josephine Muentes, and he lifts the gun and points it at the right side of her head. He doesn't point it at her shoulder. He doesn't point it at her chest. He doesn't shoot her in the leg. He's not raging in the heat of passion. He's not firing the gun. I can't remember the Yosemite Sam cartoon character, bam, 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 shooting everywhere. That's not what's going on. He is aiming directly at the most lethal part of the human body to damage or injure, the human head that contains the brain, the processing center. So he can cause that neurogenic shock Dr. McKinnon told you about. He points it directly at the most fatal part of her body with either a cocked hammer or he cocks it. And then he pulls the trigger and watches her fall, watches the plume of black powder smoke, which is a lot more than a normal gun, enough that it sets off the fire alarm in that house. These gunshots do. And the percussion, the boom, the noise of the firing occurs. And that gives him no cause for concern. He watches her drop, and he immediately, which shows you his determined intent, he doesn't fire a warning round into the ceiling. He doesn't fire anywhere else. He levels the gun directly, again, at his second target, Norma Banks. Seconds later, if that, she says, I'm standing there. I thought, what happened? The microwave, and I turned, the gun is pointed at her face. He has to cock the hammer again between the first round going into Josephine Muentes and now pointing it at her. To make the gun operable, he has to cock the hammer either with his thumb or his other hand and point it at her. More deliberate, thoughtful action that shows you the reflection that is required in premeditation. Reflection, decision making. Am I going to do it or not? Am I going to do it or not? Making a decision and acting upon it. That's reflection. And like we talked about in jury selection, it can occur in a matter of moments, and here it is. But it occurred in a matter of minutes for this defendant before he ever killed Josephine Muentes. This defendant got up here on the stand and told you, I remember loading the gun. If you remember loading the gun, then you have to remember why you loaded that gun. Why at 12:40 or 12:35 you walked down the hall and retrieved a gun and went through that lengthy, detailed loading process. Every single step is a problem-solving step to load that gun. It all takes reflective, deliberate action. Every single thing he had to do to load that gun. Even if he had to go down there and grab a magazine and stick it into a rifle and charge the handle like those officers were doing, what those officers were doing, that was premeditated. When Officer Gibson ran up and realized, I want my rifle, I need my rifle, I need 3 points of contact, he's premeditating that he's going to get a rifle. He's reflecting, and he goes back, and he unlocks his trunk, and he pulls that drawer out, and he opens the bag and unzips it. That quick, he gets his rifle out and loads the charging handle. Much faster than what this defendant did with this antiquated revolver from the 1800s, the design of it. That's plenty of premeditation. If he had gone in that room and picked up a semi-automatic pistol and shoved a magazine into it and racked the slide, that would have been premeditation. All of these things take deliberate act. That gun didn't load itself. And now he's on his second victim, and again pointing at her head. And guess what? It's effective. He hits her in the head. A bullet rips across her left ear. Powder burns to her face like we talked about. She'll have the rest of her life. And that bullet ends up in that cabinet. And then she starts running. And what does this defendant do? He shows you his intent to kill, the determination in his heart. And he follows her. And he's shooting at his own mother, this elderly woman who's moving as fast as she can get going. And she grabs her phone off the corner of the table, and he shoots at her at head level, at her head, hitting the wall, right there by the threshold. And again, to fire that round, between the round that he put in her head, he had to cock the hammer. More deliberate, thoughtful action. Again, this is not like that AR-15 rifle that Officer Gibson has, where he's able to go bam, bam. It's not a semi-automatic pistol that self-loads and ejects a shell casing and reloads. He's got to cock that hammer. Now she's in the back room, the side room, the south room, the living area, running past down towards the laundry room and the back door. And he comes around the corner and aims at her again, cocks the hammer again and again. The percussion. This is now the third round being fired at this woman. More smoke, more percussion, more blast from that black powder gun. Again, not affecting him, not affecting his determination, his intent to murder. And he puts a round right there in that door. You saw the impact to that metal door hitting on the inside of it. Somehow that didn't hit her. But he did hit her again somewhere. Either on the way out, maybe the round that went into the cottage, right there at about head level, chest level, maybe another round that scooted off somewhere else after it impacted the back right head side of her skull. 2 headshots, and now he hits a moving target with a headshot. Again, not happenstance, folks. He's shooting to the most lethal part of the body. I cannot emphasize enough to you how difficult it is to shoot a modern semi-automatic handgun. That is a difficult process. Officers have to train to be proficient at that. It is not easy to shoot with a handgun, but to hit a moving target with a modern handgun would be difficult, especially a headshot on a moving, running, moving target. Because as she's moving, her head is bobbing, it's moving. Even if she's not trying to do that, that's happening. But to do it with this gun, this black powder revolver, where he had to cock the hammer again to fire at her, now a 4th round that finds her head, possibly a 5th round that finds her head. And he's put a round into Josephine Muentes. And guess what? Now the gun's empty. Now it's empty, because it only holds 6 rounds. And now we move to Michaela Banks. Michaela Banks, in the bathroom, like I said earlier, caged in that bathroom, sends that text message to her boyfriend up in Pennsylvania. She hears the gunshots, hears the commotion. She's pressing herself up against that door, and she hears the footsteps going down that hallway into that room where the loading supplies are found. This defendant goes back, and as she waits on the other side of that door, not knowing what's going to happen, he's in there loading this gun, going through all of those steps, all of them, again, all of them, measuring the powder, pouring it in, putting the ball into each of the carriages after putting the powder in, making sure not to spill it, making sure not to tip it up or down, pressing all of the rounds in, and then putting the percussion caps on. And then he goes, after all of that, to the door. And again, this is before any of the body-worn cameras, before any of the officers get there. He goes to the door, and he starts trying to get through. Now, she says he's shooting through the door, but that door it's damaged, it's broken, and that's him trying to push through that door. He's trying to push through that door. And then he's trying to figure out, she's leaning against this door, and I want to kill her. We know that from his actions. And he's going to try to, again, find his favorite target, her head. So he takes the revolver, like she told us, and he starts moving it around, trying to figure out, where is she? Where is she? Where's her head? But he can hear her through that door. He can hear her and where she is. And so finally, like we saw, he puts a round through the center of the door, not up in the corner, not on the threshold of the door. It's not wild shots again. He doesn't even shoot into the roof. Open the door. Boom. I'm going to put one through the door. No warning shots. Nope. He puts it through the center of the door, right where she would be standing if she was in there pushing against it, right where her back would be if she was up against it like this, pressing like this, but she's not. She's down further in a crab position, low. And somehow, again, that bullet doesn't find her. That is a miracle that that bullet did not hit that girl. It went through that door and went into the wall above the tub. But that didn't stop the defendant. And again, don't forget, he had to cock the hammer before he fired that. So he's trying to get in there. He's handling this big revolver. He's cocked the hammer. Now he's fired it again. The plume of smoke, the noise, the percussion. None of that phases him. He is determined. He is determined. He's murdered the first victim. He's chased the second victim, his mother, trying to murder her. She got away. Now he's going to murder his daughter. Now he's going to murder his daughter, who he tries to convince you yesterday that he was motivated by some compassion for her or some desire to protect her. So anyways, he puts a round through the center of that door, right where he thought that he would hit her center mass, or at least in her abdomen, because he couldn't figure out where her head was, because the door was between them. And when that didn't work, and when he must have heard her moving in there, what does he do next? He puts the tip of that gun to the locking mechanism. And what does that show you? That shows you problem solving. And that is premeditation. That is reflective thought. I need to get this door open. How am I going to do it? I'm going to blow that locking mechanism apart. I'm going to put this tip of the barrel up there, and I'm going to pull the trigger. I'm going to cock the hammer. That is a sequence of problem solving, decision making. That's premeditation. He fires into that door and busts the lock, and he's able to get through the door, and somehow this girl's able to get past him. Maybe because she is wet and slippery and he can't get a hold of her. He's trying to grab her. He's trying to grab her. He's trying to grab his daughter. And she tries to get by him, and she does. And she's able to run out of that house. We just watched that in terror. You heard the screams in Officer Breacha's body-worn camera. The terror in that poor girl's mind and in her voice. So she escapes with her life. But again, not before suffering that gunshot wound at his hands. When he fires somehow, somewhere, either in the process of her leaving, remember what he says, I remember her running down the hall, maybe that's when he shot her. Somehow, maybe she's running and her leg is up in the air when it hits, but somewhere along there, he shoots her and puts a .44 caliber slug that goes through her hip into her upper leg. She has a deformed hip bone now, and the pain I talked to you about a few minutes ago, and she'll have that the rest of her life. I bring that up to you because one of the lesser included offenses, as you heard, was aggravated battery. That requires a showing of great bodily harm. This is much more than aggravated battery. This is much more than aggravated battery. This defendant was attempting to murder his daughter, and there is no ifs, ands, or buts about it. Once she escapes, it's about the time Officer Brecha arrives. He hears the screams. He actually picks up on his body-worn camera one of the rounds going off. That had to have been the round that goes in her hip, because it's not the round that opens the door. She's not hit at that point. The other round that went through the door went into the wall, not into her hip. So the round that we hear in Officer Brecha and his video, his body-worn camera video, right before you hear her screaming bloody murder inside of that house, that's the round that is going into her body, into her leg. So Officer Brecha arrives. They run out. She runs out. Her grandmother meets her. He shot you too. She's got blood pouring down her head. She runs in there and gets her granddaughter a blanket. About that time, Pearson and Gibson arrive, and they start making their way up there. As I said earlier, Gibson's on the garbage can. He can clearly be seen. He's giving verbal commands to the defendant. Show me your hands. Show me your hands. The defendant runs around the corner out of sight. Now, he tells Detective Hill he went inside. He may have. If he did it very quickly because he came right back out. And like I told you earlier, why would he come back out with all those sirens blaring and getting closer and on top of him and the fire trucks and all that noise and seeing officers out there? Why would he go back outside? He went out there because he intended to kill. It is the only reason that this defendant would go back out there with a gun in his hand, armed. And if you have any doubt about that, look at how fast it happens. Watch Officer Pearson's body-worn camera video and Officer Gibson's. As soon as Pearson's not even through telling him what he looks like, what he's wearing, when Officer Gibson encounters him through that fence and sees him and starts to pull his gun up, and the defendant fires immediately at him. And you hear the rounds going off. You can hear it on the other officer's body-worn cameras, too. You can hear it in Officer Nishida's body-worn camera, that round going off. And Officer Gibson fires off 2 rounds, and somewhere in there, this defendant fires off a second round. So he shoots and then cocks the hammer, and he shoots again, but clearly he is aiming directly at Officer Gibson. That round in that fence shows it's directly at his head, it's right in the middle of the fence, and it shows his clear, premeditated intent to murder this police officer, which is the only reason, with all that racket going on out there, that anybody would have known means that the police are here. He's just been yelled at by a uniformed officer. It's the only reason he would have been out there. And then, as I just showed you a few minutes ago, he clearly demonstrates his intent towards law enforcement when he fires 2 more rounds out the front window at these officers and then is yelling at them. You did a bunch of effed up shit to me, man. You've been effing with me since I was a kid. His intent could not be any clearer. these crimes in isolation are loaded, chock full of premeditated evidence in isolation. But when you string them together and you look at the persistent, consistent, determined, murderous intent that covers all of them, that goes from one to the next, to the next, to the next, it doesn't end until this defendant knows that that house is surrounded and he knows he has to give up. He knows he has to give up. And that's when he leaves the gun and he goes out and he complies and does everything the officers ask of him. But as far as Josephine Muentes, Norma Banks, and Michaela Banks, and Officer Darren Gibson, every single one of those shootings demonstrates premeditation. If you think about them as a spree, one after the other, just think about the sheer amount of effort that this defendant had to put in, the sheer amount of thinking, and all the decisions he had to make, all of them lining up, and all the problem solving, just to commit these crimes. And to exercise that type of violence on every single one of these, to try to put .44 caliber slugs into all four of these victims. These crimes are absolutely, and it starts with the loading of that revolver, it is absolutely impossible. It is absolutely impossible to commit these crimes in this fashion and it not be premeditated. It's impossible. He could not have done this in a non-premeditated fashion. There's no way to get around that. They are incapable of being committed without premeditation. Now, going back to the law, I've talked to you about first-degree premeditated murder. It's the same legal requirements for attempted first-degree premeditated murder of Norma, of Michaela, and of Officer Gibson. Same requirements that we have to demonstrate of premeditation, that he had enough time to reflect. The only difference is those are attempts, not completed homicides. With Officer Gibson, it requires an extra step of determining he was a law enforcement officer, that he was acting in the lawful performance of a legal duty, which is a no-brainer. He obviously was, and he told you he was. And at the time, the defendant knew he was a law enforcement officer. I've covered that with you. There's overwhelming evidence of that. So I want to talk to you about what I anticipate their defense in this case is going to be. It's a defense called heat of passion. Heat of passion. An issue in this case is whether Mr. Banks did not act with a premeditated intent to kill for premeditated murder or attempted premeditated murder, or did not have a depraved mind without regard for human life, which is the element in second-degree murder. That doesn't require premeditated murder. Because he acted in the heat of passion, based on adequate provocation, to find the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion, or that he didn't have a premeditated intent. These are the requirements. There must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. And a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. A blind and unreasoning fury. Is there anything in the facts of this case that suggests this defendant was acting and driven by a blind and unreasoning fury? Yosemite Sam, remember I talked about him shooting his guns off in all directions? Someone acting like that, someone losing it, running around the house just shooting. That's not what we have here. We have very well-aimed, very well-placed, very well-directed behavior by this defendant, trying to kill each of his victims with persistent commitment and determination, problem solving, loading the gun, which is a problem in and of itself that he had to solve, and a long, complicated process. That is not blind and unreasoning fury. Shooting one person, watching them fall, shooting them in the head, picking their head, and then picking the second victim, his own mother, pointing directly at her head, and shooting her in the head, and then following her and consistently shooting at her, attempting to murder her, and then going and sitting down and reloading, before then attacking his daughter, and then having to think about where to shoot in that door, having to problem solve to get through the locked door, because remember, she did tell you she locked that door. This is not the product of blind, unreasoning fury. But more importantly, there was no sudden event that would have suspended the exercise of judgment. And there was no suspension of his judgment. Everything he did was well judged and showed premeditated thought. There was no behavior here that would, or a sudden event that would cause a reasonable person to act the way the defendant did. This is a reasonable person standard. It is an objective standard. That's the way the law works. People are expected to act reasonably. It's an objective standard. And there is no sudden event. He had heard they were going to leave. He heard it, and then he moved around the house and he heard it again. He heard they were going to leave. And he became upset. That's not a sudden event that would have caused suspension of exercise of judgment in an ordinary reasonable person. The fact that his daughter is leaving because he is making perverted comments to her and making her feel uncomfortable, and from the time she moved in that house, she told you, and remember the way I asked her, I didn't say, when you moved in, you were staying in the back with your grandmother every night, right, because you were uncomfortable. No, I said, did you at some point go stay in the cottage with her? From the time I got there, I did. From the time I got there, I did. Because he was saying things to me that made me uncomfortable. And so I stayed with my grandmother. Norma Banks tells you the same thing. I had her with me. And it was the night before when he went into that cottage with that voice, the same voice you heard coming out of the front door and that body-worn camera yelling at those officers about effing with him through his whole life. Same voice. You're either going to be with me or you're going to leave. You're either going to be with me in a sexual relationship or you're going to leave. And when he found out the next day that she's going to leave, would that have suspended the exercise of judgment in an ordinary, reasonable person? No. And there was no sudden event that caused this. And a reasonable person, well, first of all, a reasonable person wouldn't have had lascivious, perverted desires for a 17-year-old daughter. But a reasonable person would not have lost normal self-control and gone into a blind and unreasoning fury when they found out that their daughter was moving out or leaving with their mother, with the grandmother. Now, a reasonable person would not have had time to cool off. Let's just say he was acting reasonably. Let's just say there was some sudden event that caused this. And the sudden event, folks, what we're talking about is like a person coming home and finding their spouse in bed with someone else. That's the type of event we're talking about. Something that would drive a person into such fury and anger that they would act in a blind fashion, an unreasoning fashion, and definitely not a fashion where they are reflecting and premeditating. But let's just assume, for arguendo's sake, that occurred here. A reasonable person wouldn't have had time to cool off. Really? He walks down the hall and sits in a room and goes through this lengthy process of finding his firearm, getting out the loading materials, and then going through that detailed loading process. Even if a person had been driven to some type of blind and unreasoning fury, there would have been plenty and ample time to cool off. Michael Banks, this is the last element that's required, was in fact so provoked and did not cool off before he committed the act that caused or attempted the death of the victim. He was provoked, he was angry, but not like this, not even close. And this isn't the type of event that would have suspended exercise of judgment in an ordinary, reasonable person. He didn't cool off because he decided not to cool off. He was provoked, but then he started premeditating because he had formed an intent to murder these people. What were you doing? What were you doing? I was going to shoot everybody. Again, this requires he acted in the heat of passion based on adequate provocation. This is not adequate provocation, folks. It's not even close. Lesser included crimes. I'm going to talk about these real quick, and then I'm going to yield to the defense in their closing for you. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. So what that means is, and that's a direction given to you by the judge under the verdict form instruction and how to go through the verdict form. So your process is, as a jury, you look to the charged offense. With Ms. Muentes, first degree premeditated murder. It must be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. When you start deliberating, if you unanimously find that he committed the premeditated murder of Josephine Muentes, you check guilty. And then you make the findings about carrying a weapon and discharging a firearm causing death. And you're done with her count. You never look at second-degree murder. You never look at manslaughter. It's only if you find that we have not proven that this defendant in all of these detailed processes premeditated that you would ever consider second-degree murder as an option. Same is true for the attempted murders of Norma Banks, Michaela Banks, and Officer Darren Gibson. The same is true for them. You look to the charged offense, attempted first-degree murder of Norma Banks, attempted first-degree murder of Michaela Banks, attempted first-degree murder of a law enforcement officer, Darren Gibson. It's only if you find we haven't proven those beyond a reasonable doubt that you would then move to the next level. Murder in the second degree. Let's talk about this real quick. So this is what second-degree murder is. It's sometimes called depraved mind murder. We would have to prove to you that the victim is dead. We would have to prove that she is, that her death was caused by the criminal act of the defendant. We would have to prove to you there was an unlawful killing of the victim, not by a premeditated intent, but by an act that is imminently dangerous to another and demonstrating a depraved mind without regard for human life. And that is described as one that is done from ill will, hatred, spite, or an evil intent. And it's one that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and of such a nature that an act itself indicates an indifference to human life. Does that fall? Does this describe what he did to all of these people? Yes, it describes what he did to Josephine Muentes, but we do have premeditation. We do have premeditation. Is what he did, does it demonstrate a depraved mind? Doing an act, was it imminently dangerous to Josephine Muentes and demonstrating a depraved mind when he shot her in the head? Yes, sure it was. But he premeditated and reflected upon what he did. He didn't shoot her wildly. He pointed the gun at her head. He loaded the gun. He walked down the hall. He lifted the gun and aimed it at the side of her head. We have premeditation, and we have it in spades. Was it done from ill will and an evil intent? You bet it was. You bet it was. These two, the evil intent is working hand in hand with the premeditated murder in this case. There's overwhelming evidence that this defendant's criminal intent was an evil intent. His intent to murder Josephine Muentes, to murder his mother, to murder his daughter, and to murder police officer Darren Gibson. And they are all of these crimes, and the facts of this case are absolutely saturated in evil. There's no other way to describe this case other than one that is evil and full of it. It's full of evil, but it's also dripping with premeditation. Every single one of these crimes was premeditated. Every one of those 44 caliber lead bullets that this defendant cocked that hammer and pointed and fired at Josephine Muentes, Norma Banks, Michaela Banks, a 17-year-old daughter. And then when he went back out there knowing there was law enforcement out there, saw a police officer raise that gun and fired at him, not once, but twice. Every single one of those lead bullets carried with it this defendant's premeditated, malicious, and evil intent. And there's no mistaking that. Manslaughter is simply committing an act that causes death. There is no requirement of premeditation or evil intent. That's not what happened in this case. This wasn't a manslaughter. This defendant intended what he did. He premeditated what he did. I will come back up here in a few minutes after Ms. Dunker finishes her closing statement to you. And I'd ask that you please give her the attention that you've provided the state. I'd also ask that you make sure that her arguments comport with the evidence in this case and what you heard in the last several days. Then I'll have another opportunity to speak with you.
All right, we're going to go ahead and take our comfort break. I'll bring you all in when you're ready. Thank you.
Your accident?
seated. Ms. Dunker, you may give your closing argument.
Thank you, Your Honor. May it please the court, counsel, good afternoon, good morning-ish. I don't intend to take up too much of your time today, but I want to be clear. I hope that to you is not a sign for any lack of advocacy. The state of Florida has a very important job to do. They have the job, they are the only ones with the job of bringing evidence to you. The burden of proving that evidence beyond a reasonable doubt. And it is important for them to go through that evidence with you. But there's something the judge read to you this morning that I want you to keep in mind when you go back to deliberate. It's not the quantity of the evidence. It's not the 400 photographs. It's not the exhibits. It's not the number of witnesses. It is the quality of the evidence and what that evidence proves to you. I'm going to focus my time a little bit on really the main issue that I think is going to be presented to you when you go back there to deliberate. And that's going to be the issue of premeditation. Killing with premeditation is killing after consciously deciding to do so. Consciously deciding to kill. The mind is a complicated, beautiful, sometimes scary thing. And I don't envy the position that you all are in because you have the job of going back there and getting into the mind of Michael Banks, deciding for yourselves what was he thinking, why was he doing what he was doing. His mind was blank. It was as if he was a robot. Those are the statements that he made to Detective Hill, that Detective Hill didn't want to immediately own up to, but as you heard, eventually had to. It was as if he wasn't there. He had a blank stare. Those were the statements that Michaela Banks said to you. He was non-responsive. He was looking off at where the cat stuff was. That's what Norma Banks told you as Michael Banks was shooting at her. That is what they saw in her son, Michaela's father. That is all part of the evidence too. My computer files are important. Those are the first words out of Michael Banks' mouth after he's taken into custody. What in the world does that have to do with anything? Again, that gives you evidence as to his state of mind. What was he thinking? What was he intending? No one can testify to that. Not Detective Hill, not any of the police officers, only Michael Banks. And as we talked about yesterday, it's entirely up to you. You can listen to Mr. Banks' testimony, and I just ask that you treat him like any other witness. You can decide to believe all of his testimony, none of his testimony, or part of his testimony. Just like you can do with the law enforcement officers and the other witnesses that you heard from throughout this trial. But what is the proof that he consciously decided to kill Josephine Winters? What is the proof that he consciously wanted to kill his mother, his daughter, Officer Gibson? It's not just going through the actions of loading a gun. It's what was going through his mind. And you have to look at the evidence and you have to decide that for yourselves. Not me, not Mr. Harmon, just you. Mr. Harmon spoke to you about some of the statements that Mr. Banks gave to Detective Hill. What's interesting, what you heard yesterday, is that the prosecution, they have the option to introduce a video of that statement. so that you yourselves could hear the words directly from Mr. Banks, what he said, what he didn't say, and whether or not Detective Hill was misconstruing his words. You yourself would have had the opportunity to review that statement and watch his mannerisms, listen to the tone of his voice, listen and watch how he's interacting with law enforcement. But you don't have that, because the prosecution has decided not to give you that evidence. You can ask yourselves why. Why didn't they give me that evidence? Because when the judge defined for you what reasonable doubt is and where you can find reasonable doubt, she told you can find reasonable doubt in the evidence, in the conflicts in the evidence, and the lack of evidence. Think back to the exchange between Mr. Banks and Mr. Harmon yesterday when Mr. Banks was testifying. And certainly they did not agree on everything, right? Won't say that. But there was a lot of things that Mr. Harmon said that Mr. Banks agreed with. You were trying to kill your mother. Well, it certainly looks that way. But don't misconstrue that as some sort of confession that that was his intent all along. And take that same lesson when you're listening to the statements that Detective Hill claims that Mr. Banks made. Detective Hill told you, Michael Banks emphatically told him he saw law enforcement officers and he shot at the law enforcement officers. But you heard me point out to Detective Hill that that's not exactly what he said, right? He saw someone, he heard someone. He didn't see a police officer, he saw someone. And that may not seem like a big difference, but it is. And that's just one example of many as to how it would have been beneficial for you to see and to hear Mr. Banks' statement, but the prosecution did not give that to you. I want to talk to you now about Officer Gibson's testimony. And I want to be perfectly clear, when I'm talking about Officer Gibson, no one in no way, shape, or form is accusing him of doing wrongdoing. He did his job that day. As Mr. Harmon said, he responded, he went to the threat, he acted appropriately. I'm not here to criticize the actions that he had. But I'm here to tell you, Officer Gibson was shooting blind. He didn't see who he was shooting at. He didn't see anyone with a gun. He certainly heard the shots coming at him and was justified in shooting back. But it's important as to what he saw or what he didn't see, because the same goes for the other side of the fence. What did Michael Banks see? What didn't he see? And again, what were his intentions in shooting the gun? This is the viewpoint that Officer Gibson had as he was shooting the gun. It is not, as Mr. Harmon described to you, right in front of that mesh fence. And here's how you know that. These bushes right here, that's the property line. Go back and watch the video. Go back and look at the crime scene photographs. And this is before Officer Gibson started shooting, before he, quote unquote, goes off the mark or off the X. He's not standing in front of that mesh screen. He's standing on the property, and you can see the black car right here. That is the neighbor's car. He's standing right next to it. Officer Pearson is just beyond him. And that's important, again, when we're considering intent. And we know that Officer Pearson is not standing in front of that mesh screen because, again, his gunshots are shot at an angle. That is that wood fence that is the neighbor's fence. We know that the shots were coming from that way, towards that property line. These bullet holes in the mesh that came from where Mr. Banks was shooting from, those are straight ahead. That is not where Officer Gibson was standing. Those are straight circle holes. They're not at an angle. He wasn't shooting towards the property where the neighbors were, where Officer Gibson was standing. And then, what about that hole at the bottom? Is that an intent to kill? What's he aiming at? He's aiming at nothing. He's shooting blind. And the jury instructions are very clear to you. The only count that Mr. Banks is charged with is shooting and attempting to kill Officer Gibson. Okay, so all of these other shots and such that Mr. Harmon is talking to you about, those are not relevant as it pertains to what is his intent in shooting through that mesh. I can't answer that for you. I can't tell you what his intent was. Mr. Harmon can't answer that for you. Again, that is a job that only you, the jury, will have the opportunity to decide after looking at all the facts. But I would encourage you, again, to look through the photos again if you need to. Look through the video, the body-worn camera if you need to. Officer Gibson was not standing anywhere near that mesh screen. He was on the neighbor's property by Officer Pearson. This is a screenshot from Officer Pearson's body-worn camera. And here's why that's important. You can see this is before he goes over to the neighbor's yard. He is in front of that mesh screen. He's standing a considerable amount, a little bit back, kind of by that tree, which is much closer than Officer Gibson was standing. Because remember, go back and look, Officer Gibson's standing on the opposite property line, has some bushes and such in his way, and is standing much further back. And you don't have to take my word for that, you could go and review that. But this is the viewpoint that Officer Pearson has. And remember, my question to him was very simple and purposefully not even in a leading way. Why did you go over to the neighbor's property? Why did you go stand on a garbage can? And his response was simple, because I couldn't see. I was obstructed, my view was obstructed. So he had to go over to the neighbor's property and stand on top of a garbage can so that he could see into the backyard. Again, that all goes to what Officer Gibson was or was not able to see, but more importantly, what Michael Banks was and was not able to see. He was not shooting at Officer Gibson. Was he shooting at anyone? Why was he shooting? Again, questions I can't answer for you. Only you, the trier of fact, will be able to answer those questions. The prosecution, again, has an important job to do. But I ask that you remember when you go back to deliberate about all of the things that we talked about during jury selection. And I ask that you hold yourselves to the promises that you made, that you would consider all of the evidence, that you would view it all fairly and equally. And only then, after you've had the chance to do that and to deliberate with your fellow jurors, I ask that you return a fair verdict, a true verdict that you can all agree to. Thank you.
Mr. Harmon?
I'm just putting this back up again. Again, this is from Officer Pearson's body-worn camera. If you look, you can see through that. I can see through it. Anyone in this courtroom can see through that fence and see what's on the other side. Yeah, Officer Pearson wanted to get a better view. He wanted to be able to get a better view into the backyard and around that house. And is being on top of the garbage can a better view than that? Sure it is. Sure it is. But remember, Officer Gibson was next door covering behind the defendant's pickup truck, taking cover when he hears Officer Pearson yelling, and he comes running over into that yard, and he's facing directly at that. Counsel just showed you a picture of Officer Gibson's body-worn camera, and it's similar to the beginning of this video, that's not the view Officer Gibson is seeing as he's approaching the scene. That's from his chest, and you're seeing his hands and his weapon, just like in that photograph she showed you. His vision is above all of that. And on that property line, he can see into that mesh, through that chain link fence, and Officer Gibson tells you he sees a person come out. He sees what appears to be a gun, and the person fires at him twice. He tells his dispatcher almost immediately, which tells you that's what happened. It tells you that's what happened. Why would Officer Gibson come in here and testify otherwise to that? And not only that, this thing about what the defendant told Detective Hill. What Detective Hill was confronted by the defense about was that what Officer Pearson yelled at the defendant, whether he simply yelled at him or whether he told him to put his hands up. That was the confusion between the two of them. It had nothing to do with who or what he saw. The defendant claimed on the stand yesterday, he actually admitted to you on the stand that he saw a person. He just didn't know it was a police officer. He told Detective Hill, I came out, I saw a person through the chain link fence. It was a police officer, and I fired at him twice, which is exactly what Detective Officer Gibson told you happened. He saw a person raise a gun. All these questions about assuming that it was a gun, there's no assumptions when someone shoots at you twice and then tells a detective that a couple of hours later that he shot at a police officer. That's what he told Detective Hill. There was no confusion on Detective Hill's part about that. There is no evidence he misconstrued anything, including when he was confronted with an Axon AI prepared transcript of the defendant's statement, where he was being confronted that the defendant said, I was then, in the transcript. And when you all were removed and you came back, Detective Hill told you, I listened to the audio, and the defendant says, as I had in my notes, I was mad. There's nothing Detective Hill told you about the defendant's statements that were misconstrued. He told you the ultimate points the defendant made, and you saw the defendant's testimony yesterday and how long it took for me to cross-examine him. One of the things the judge is going to tell you when you're assessing the credibility of a witness, and you are to treat the defendant, counsel said it perfectly, please treat her client like you would any other witness. Well, you're told to do that in the legal instructions. And the things you're supposed to look to one of them is, was he honest and straightforward in answering the attorney's questions? Was he honest and straightforward in answering my questions? Or was he making speeches, giving advocacy to you, giving, like I asked him, a closing statement? When he points out, oh, they both said I had a blank look or whatever look on my face, I would argue that's a look, a murderous look of determination is what they saw on their face. They had never seen him in a state of having an intent of murdering, trying to murder 4 people, I'm sure. And that was the look on his face. But the defendant went way out of his way. He was the most non-responsive witness in this trial. He didn't want to answer my questions. How many times did I ask him? You had to cock the hammer before you fired the gun, talking about the officer on the other side of the fence. He went off on some tangent. You had to cock the hammer on the gun before you fired. I had to ask him 3 times before he answered yes. After just telling you that he had fired twice at somebody he didn't know was a police officer. Well, he told Detective Hill he knew that was a police officer. There is no doubt about that. Officer Gibson was not shooting blind, and this defendant was not shooting blind. He was shooting at what he thought was a police officer and who he knew to be a police officer. Officer Gibson was seeing a person pointing something at him and hearing gunfire, and he was firing back as he retreated. And that's why those bullets come in through the PVC and hit the wood at a very, very slight angle, because he's firing as he's retreating. And if he hadn't have retreated, those rounds would have hit him. Counsel brings out the, see if I can find it here, this lower shot. Remember how quick these shots are? So he has to cock the hammer, he fires, and then the gun recoils, and then he's got to cock it again and shoot it that fast, almost as if the old westerns, he's fanning the hammer. and the gun goes down. It goes down when he does that. That's inaccurate follow-up fire is what that is. When he's trying to shoot rapidly, he has inaccurate follow-up fire. The issue about the defendant being in a robotic state, that was out of the defendant's mouth yesterday, telling you that he was acting in a robotic state. He may have even said,
The jury's to rely on their own memory as to what the evidence was in this case. Continue.
he may have even said delusional. That's my memory. He said that to you at one point. He was in a fog. There's nothing in these facts to indicate that he was acting delusionally or in a fog. That's not what happened in this case. You cannot commit these crimes the way they were committed in a delusional fog. Josephine Muentes. You heard the testimony of Michaela, you heard the testimony of Norma. But this woman, Josephine Muentes, 52 years of age, that may sound old to a couple of you, but I can assure you it's not. Once you get close to that age, you will not think that that is an old age. Miss Muentes, like everyone else on the face of this planet, wanted to live. She was 52 years old. She had a life. She lived there with her friend and roommate. And this defendant decided that she was going to die because he got angry because his daughter rejected his perverse and perverted demands of her the night before. Not just suggestions of being his lover, his demands. And this woman was just there. She was just there. And he shot her in the head. When you come back with your guilty verdict of first-degree premeditated murder, you're going to tell this defendant that Josephine Muentes is more than just a person
Objection,
who was
improper
there.
argument.
Overruled, go ahead.
And you're going to tell him that he is accountable for every act he committed that day, for every attempted murder, including the attempted murder of Officer Gibson, and including the attempted murder of the roommate that was in the house.
All right, let's pick up where we left off, and that was on page 35.
Your Honor, will you take that down?
Sure. Okay? Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything that I may have said or done that made you think I prefer one verdict over another. Next, page 36, rules for deliberation. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the laws that set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits received in evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or because you're angry at anyone. 4, remember that the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if Michael Banks has been proven guilty or not in accord with the law. It is my job to determine what an appropriate sentence will be if Mr. Banks is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Lastly, on page 37 is submitting the case to the jury. In just a couple of minutes, you're going to be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back into the courtroom when you return. During deliberations, jurors must not communicate, During deliberations, jurors must communicate about this case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until that juror returns. You are not to communicate with anyone outside of the jury about this case. Until you have reached a verdict, you must not talk about this case in person, through the telephone, writing, or any other kind of electronic communication such as an email, social media, or any other means. Do not contact anybody to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices. That includes smartwatches, smart eyeglasses, any of that, here in the courtroom. The rules do not allow you to have any of those types of electronic devices in the jury room. Kindly leave those devices on your seats where they will be guarded by the courtroom deputy while you deliberate. If you have any of those devices in the jury room, you're to give them to the deputy when you go back to consider your verdict, and he'll bring them back in here and guard them while you're deliberating. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in your note. If you have a question, I'm going to need to talk to the parties before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent to the jury room when you begin to deliberate. In closing, let me remind you that it's important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. There's no other evidence to be received in this case. Even if you do not like the laws that must be applied, you must use them. For more than 250 years, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. All right, so I think your lunch is back there. And so when you get back, you can choose to eat your lunch and then start deliberating, or start deliberating and eat your lunch and do a working lunch. Whatever you just decide to do is completely up to you. You can take your notes, the jury instructions back with you. We're going to have the exhibits sent back. It's going to take us a couple minutes, make sure they're all together, and those will get back as well. You'll have the ability to play any of the exhibits if you choose to back there on the equipment we have back there. So with that being said, you may now retire to deliberate your All right, so my understanding is the jury's reached a verdict, is that accurate? All right, just in case, I don't know what the verdict is, but just in case, has everybody looked at phase 2, if we're gonna go into that at all?
Judge, I completely forgot about that, but.
Yeah. All right, I'm gonna need, Ms. Schlemmer, here I am assigning you, even though you don't work for me, you and Ms. Mazzari to be looking at that, because I've gotta get that printed if in fact, the jury comes back and frankly, I think that would go anyhow, because it's a count. You know what I mean? So take a look at it so we can make sure, so I can tell them to start printing if they're okay.
Did the court send over the basic instructions or just the original version?
I can't hear you.
Did the court make any edits to the?
I haven't touched that. I don't ever look at that until I need to.
Okay.
So that's why I'm asking you guys to. Let's bring in the jury.
Yes, Your Honor.
Can you forward that? Can you forward them over, please?
Yes.
Thank you.
You know what? Let me go ahead because my assistant might have.
Okay.
All right, so give me 1 second. Let me see if she did. Come on, man. All right, let me go ahead and send these to you too. I don't know whether she's touched them or not, but that's why, let me send you the ones I've got in the file. Okay, sent.
Thank you.
I would leave it. I would leave it just in case we need to send that back, so just leave it on the card. I like the proactiveness, but there may be a phase 2.
All right, here's Aaron.
All right, the jurors are all in the courtroom. Everybody may be seated. So I am going to use my keen powers of observation and presume that juror number 4 is the foreperson. Am I correct?
Yes, Your Honor.
All right, you can stay seated. I used that because I saw you the one carrying the paper. Okay? All right, so my understanding is that the jury has reached a verdict. Is that correct?
Yes, Your Honor.
Can you please hand the verdict form to the bailiff? Okay, Madam Clerk, please publish the verdict and poll the jurors.
State of Florida versus Michael Monroe Banks, case number 24 CF 817, trial division 2. Verdict. We, the jury, finds as follows as to count 1. The defendant is guilty of first-degree murder as charged. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. During the commission of the offense, did the defendant actually discharge a firearm? Yes. During the commission of the offense, did the defendant actually discharge a firearm and, as a result of the discharge, cause the death of another person? Yes. We, the jury, finds as follows as to count 2. The defendant is guilty of attempted first-degree murder as charged. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. During the commission of the offense, did the defendant actually discharge a firearm? Yes. During the commission of the offense, did the defendant actually discharge a firearm and as a result of the discharge inflict great bodily harm to another person? Yes. We, the jury, finds as follows as to count 3. The defendant is guilty of attempted first-degree murder as charged. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. During the commission of the offense, did the defendant actually discharge a firearm? Yes. During the commission of the offense, did the defendant actually discharge a firearm and, as a result of the discharge, inflict great bodily harm to another person? Yes. We, the jury, finds as follows as to count 4. The defendant is guilty of attempted first-degree murder of a law enforcement officer as charged. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. During the commission of the offense, did the defendant actually discharge a firearm? Yes. At the time Michael Banks committed the offense, was Officer Darren Gibson a law enforcement officer? Yes. At the time Michael Banks committed the offense, was Officer Darren Gibson engaged in a lawful performance of a legal duty? Yes. At the time Michael Banks committed the offense, did he know that Officer Darren Gibson was a law enforcement officer? Yes. So say we all dated this 20th day of August 2026, signed by the foreperson of the jury. Juror number 37, is this your true and correct verdict? Juror number 1, is this your true and correct verdict? Juror number 4, is this your true and correct verdict? Juror number 7, is this your true and correct verdict? Juror number 8, is this your true and correct verdict? Juror number 11, is this your true and correct verdict?
Yes.
Juror number 18, is this your true and correct verdict?
Yes.
Juror number 19, is this your true and correct verdict?
Yes.
Juror number 23, is this your true and correct verdict? Juror number 26, is this your true and correct verdict?
Yes.
Juror number 31, is this your true and correct verdict?
Yes.
And juror number 32, is this your true and correct verdict?
Yes.
All right, so ladies and gentlemen of the jury, there's something additional that we're gonna need you to do. I'm gonna need you to step back outside into the jury room while we have a discussion. Just give us a few minutes, thank you. Feel free to use the restroom and grab a snack while you're back there. All right, the jury has found Mr. Banks guilty of all charges and answered all the Mr. Banks, you can have a seat. And had answered all the interrogatory questions in the affirmative. We have one count that was severed out, and that's the felon in possession count. Are you all wanting this jury to make the determination on the felon in possession count, Ms. Dunker? Do you want to have a conversation with your client?
Well, I would just point out, I had a motion to sever, so it was my request for a separate trial. That would still be my request, but.
Not a problem, but just talk to him.
I understand.
Judge, just so the court's aware, we do have the 2 witnesses we would call for the second phase.
Okay. All right, so let's take a look at the instructions. I emailed them to everyone.
We got it.
Ms. Dunker, let me ask you this, do you want me to put that antique firearm language in the definition of firearm here? All right, so let me grab that and do that. All the stuff about silencers and frames and machine guns and destructive devices from it, like we did from the original definition.
Yes, I don't have a problem with that.
Yes, states
Okay.
like that, Judge.
Okay, let me know when you've all had an opportunity to look through the Phase 2 instructions and tell me of any additional deletions or additions that you all want in there. Because then I'll have my assistant start printing them. The defense, are you okay with the instructions? Any additional?
We are, Judge.
All right, perfect. I'm gonna get those printed.
We're not, Judge.
Are you, do you want to say anything in closing?
Probably just briefly.
It's Ms. Erie, deputy.
So let's use our idea of brief.
Oh, we're not gonna do opening or closing, we have discussed that with Mr. Banks.
Okay, so you have discussed it with Mr. Banks and he's okay with that. Mr. Banks, is that accurate, sir?
Yes, ma'am.
Okay.
Judge, I was just wondering, Ms. Dunker nor I have ever done one of these bifurcations, because, I mean, frankly, usually they're dropped afterwards.
Right.
Do they have to prove that the civil rights weren't restored, like through a penitentiary pact?
So,
Because-
so usually they introduce a certified copy of some
Right.
sort of a letter
Right,
that says that he hasn't been pardoned or
right, and they
whatever.
don't have that.
What do you plan on doing with that?
Yes, so at this point, the state does not have a copy of the defendant's clemency letter. We're still prepared to go forward. It is not directly one of the elements we have to prove for this count.
Okay.
We can go forward now. Then they're not gonna be able to prove it, so.
Yeah, I'm just looking at the law, the case on it, it says that once the state proves a qualifying felony conviction, the burden shifts to the defense if they claim an affirmative restoration of specific.
Okay.
Executive bias.
What case is that, Scott? Not that I don't trust you.
No, it's under 790.232.
Wait. Get tuck letter.
I'm trying to find a case inside of it.
Thank you. And you have the separate verdict form?
Yes, Your Honor.
Right, I completely forgot that. I can look.
All right, let's bring in the jury.
Was he gonna give us the case?
I couldn't pull it up, Carolyn, it won't let me access it until I go.
Can we have just one more?
May I have
minute?
that?
Sure, not a problem.
just reading the comments in one of those instructions, and it seems to imply it's an affirmative defense.
Okay.
So what we plan to do, we'll just preserve it by doing a JOA or anything for that,
Okay.
just an abundance of caution.
All right, let's bring in the jury. All right, all the jurors are in the courtroom. Everybody may be seated. You're gonna see some additional instructions that are on your chair, okay? So I'm gonna begin on page 1 here. Everybody with me? All right, members of the jury, there is another instruction you must now consider. For legal reasons, you are not to consider this instruction until reaching your first verdict. All instructions provided to you during what we're gonna call the phase 1 trial of this proceeding still apply. The additional instructions I'm about to read to you are applicable to this second part of the trial. You will now hear additional evidence. You will consider this additional evidence and the evidence you heard at trial in making your decision. All of the previous instructions that I have given you still apply to your verdict as to whether or not the state has proven each of the required elements beyond a reasonable doubt. Page 2, felon in possession of a firearm, count 5. To prove the crime of felon in possession of a firearm, the state must prove the following 2 elements beyond a reasonable doubt. 1, Michael Banks had been convicted of a felony, and 2, after the conviction, Michael Banks knowingly owned or had in his care, custody, possession, or control a firearm. Convicted means that a judgment had been entered in a criminal proceeding by a court pronouncing the accused guilty. A firearm means any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. Care and custody means immediate charge and control exercised by a person over the named object. The terms care, custody, and control may be used interchangeably. To prove Michael Banks possessed, in quotes, a firearm, the state must prove beyond a reasonable doubt that he, A, knew of the existence of the firearm, and B, intentionally exercised control over it. Control can be exercised over a firearm whether it is carried on a person, near a person, or in a completely separate location. Mere proximity to a firearm does not establish that the person intentionally exercised control over it in the absence of additional evidence. Control can be established by proof that Michael Banks had direct personal power to control the firearm or the present ability to direct its control by another. Possession of a firearm may be sole or joint, that is, 2 or more persons may possess it. Knowingly, in quotes, means an act done voluntarily and intentionally, and not because of mistake or accident or other innocent reason. Now we're going to put these down for a second. I'm going to ask the state, does the state have any additional evidence it wishes to present for this charge?
Yes, Your Honor, the state will call Gary Sindel.
All right.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Good afternoon. All right, so what I need you to do, get close to that microphone, make this part even with your mouth, and speak loudly into it. Do me a favor and spell your last name for us.
Sandel.
Thank you. You may proceed.
Thank you, Your Honor. Good afternoon. Can you tell the jury where you are currently employed?
I am an investigator with the State Attorney's Office.
And just generally speaking, what are some of your day-to-day responsibilities as an investigator?
Mainly to locate witnesses, sometimes deal with evidence, locate witnesses, get addresses, information to be able to do subpoenas mostly.
Okay. So you assist in anything that might be necessary as the State Attorney's Office is preparing any case or criminal investigation?
Yes, ma'am.
Okay. Your Honor, I am showing defense what has been pre-marked for identification as State X. And may I approach the witness?
You may. Do you have any objections to this exhibit?
We have no objections.
All right, it will be admitted.
Thank you. And may I publish?
You may.
So I'm now publishing what has been admitted as State Exhibit X. So I'm showing the jury State Exhibit X. Can you tell the jury, were you present when these prints were taken that you recognize?
Yes, ma'am.
Okay. And can you explain to the jury, when we're talking about the process of rolling prints, specifically in this case, what did you witness happen?
I witnessed the deputy take each of the fingers of the defendant and roll them, put ink on them and roll them onto the paper.
Okay. And as you're witnessing this individual's prints being rolled onto State's Exhibit X, do you see in the courtroom the individual who you witnessed getting his fingerprints rolled onto this card that is State's Exhibit X?
Yes, ma'am.
Can you point to him and identify him?
He's to my right. He's wearing glasses. He has a dark suit on, a black tie, and a white shirt.
Your Honor, may the record reflect that the witness has identified the defendant?
It will.
May I have a moment to confirm?
You may.
And just the last thing on State's Exhibit X, at the bottom left-hand corner, is there anything you recognize on this exhibit to make you know that these were in fact the same prints that you witnessed being rolled in court?
That's my signature, and I also printed my name.
Your Honor, the State will pass the witness.
Any cross?
We have no cross for investigation.
All right, thank you. Take care. State may call your next witness.
Your Honor, next, the State calls Monique Polisi.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Good afternoon.
Good afternoon.
All right, we saw you yesterday. You know the score with that microphone, and we all know how to spell your name. You may proceed.
Thank you. Good afternoon. Can you briefly refresh the jury's memory on what your current role is with the Tampa Police Department?
Good afternoon. I am a latent fingerprint specialist.
And I think we briefly discussed it with your prior testimony, but can you explain to the jury what a known print is?
Yes, a known print is the intentional recording of the friction-rich skin on the fingers or on the palms, taken from a known individual for identification purposes, usually with black printer's ink and placed onto a white contrasting background.
And in the course of your duty as a latent print examiner, have you ever done a comparison between known prints and certified copies of judgments and sentences?
Yes, I have.
Is that what you were asked to do in this case?
Yes, it is.
Your Honor, at this time, the state offers into evidence what has been pre-marked as State's Exhibit Y.
All right, any objections?
No objection, Judge.
It'll be admitted.
Okay. First, I'm going to publish what has been admitted as State's Exhibit X. Can you tell the jury, is this a known print or judgment and sentence that you're recognizing here?
This is a known print.
Okay. Were you given this known print to make a comparison?
Yes, I was.
Okay, and how do you know you were given this known print to make a comparison?
The markings in red are my handwriting.
Okay. And as we were looking at State's Exhibit Y, do we see similar markings on State's Exhibit Y?
Yes.
And as we were looking at Stage Y, as we were looking at the comparison of this exhibit, I just want you to briefly read for the jury the name on the top of Stage Y here that you see under the state of Florida.
Michael Monroe Banks.
And can you read for the jury under counts and crime what those two crimes are?
Aggravated battery, pregnant, and battery second offense.
And as you were going through and we saw your markings on these two exhibits, were you able to ultimately make a comparison of whether these same prints taken in State's Exhibit X and State's Exhibit Y were of any comparison value?
Yes, they were.
Okay, and what was your conclusion as to that, given they did have a comparison value?
I identified the same individual, Michael Banks, his finger number 7, left index.
Your Honor, may I have a moment to confirm?
You may.
The state will pass the witness.
Any
No questions.
cross-examination?
No.
All right, thank you, ma'am. Have a good one. State may call your next witness.
Your Honor, at this time, the state rests as to phase 2 of the trial.
Okay. Any, let me have the parties up at the bench. All right. Ladies and gentlemen, before we proceed further, I'm going to ask you, leave all your things and please step in the room. Thank you. All right, everyone, I'm going to put the sites that I was talking about when we were up at the bench. Benitez versus State is 172 Southern 2nd 520. It's a 1965 case. Then we have Hernandez versus State 289 Southern 2nd 16. That is a 1974 case. And then we have Parker versus State 263 Southern 3rd 192, that's a 2018 case. And, you know, I could keep going, but, you know, all of these cases say that what the statute requires for the state to prove are the two elements that are in the jury instruction, that the state is not required to prove a negative, which is that his rights were restored, that instead that becomes an affirmative defense for the defense. And for those reasons, I denied the motion for judgment of acquittal, just so that everybody knows. All right, so, Mr. Banks, we're here. We're in a little mini trial, basically just on count 5, the felon in possession count. And so just like in the first trial, you're presumed innocent, right? You have the right to remain silent. If you take that right, the jury is not to consider your silence in any way in deciding your verdict. You also have the right to testify if you so choose. Once again, like we discussed during the colloquy in the first trial yesterday, and I believe the day before yesterday, we talked a little bit about it, is that this is your right. Your attorneys may have an opinion, but ultimately the decision to testify or not is yours and yours alone. Do you understand that?
Yes, ma'am.
And do you understand your right to remain silent? You understand your presumption of innocence. You understand what, while you have all those rights, you also have the right to testify if you want.
Yes, ma'am, I understand.
Do you feel like, are you going to testify in this portion of the trial?
No, ma'am.
All right. And is that a decision you've made on your own, and is it voluntary?
Yes, ma'am.
Did anybody force you, threaten you in any way to get you to make the decision not to testify?
No, ma'am.
Did anybody promise you anything in any way to get you to not testify?
No.
Did you have ample opportunity to think about this?
Yes, ma'am.
And did you have enough time to talk to your attorneys if you wanted to?
Yes, ma'am.
Do you need to talk to them anymore?
Not for this.
Not for this? Do you have any questions at all about testifying or not for me?
No question.
All right, thank you. Let's bring the jury back in.
Yes, Your Honor.
Your dinner.
All right, the jurors are all in the courtroom. Everybody may be seated. Okay, so, ladies and gentlemen, I already read to you page 1 and page 2 of the instruction, which dealt with the actual instruction as to count 5, the felon in possession of a firearm charge. Now we're going to turn to page 3, possession of a firearm. If you find that Michael Banks committed the crime of felon in possession of a firearm, and you also find beyond a reasonable doubt that during the commission of the crime, he actually possessed the firearm, you should find him guilty of felon in possession of a firearm with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The term firearm in quotes does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess, in quotes, a firearm means that Michael Banks, A, carried a firearm on his person, or B, a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. And then we go to page 4, verdict. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to count 5. The verdict must be in writing, and for your convenience, another verdict form has been prepared for you, and it is as follows. Once again, the top is just the style of the case. We, the jury, find as follows as to count 5 of the information. Check only A or B and any applicable findings below. A, the defendant is guilty of felon in possession of a firearm as charged, and 1, during the commission of the offense, did the defendant actually possess a firearm? And there's a place for you to put yes or no. B, the defendant is not guilty, so say we all, dated this blank date of August 2026. And there's a spot for the foreperson to sign their name and a spot for the foreperson to print their name. Does the state wish to make a brief closing argument?
Yes, Your Honor.
You may.
Thank you.
Felon in possession of a firearm. As the court just instructed you, for legal reasons, we could not have you consider this count as you were going and deliberating on the first 4 counts of or indictment that you just came back and returned a verdict for. However, the one thing I do just want to emphasize with you is that first instruction you were just given is that all these same rules and all these same evidence of phase 1 of the trial applies to this count as well. So every shot that we proved was shot by the defendant in phase 1 of the trial is the same reason as we are going through the evidence in this case, and we are proving our second element that the defendant actually possessed a firearm. These same facts, these same evidence also prove up this count as well. And as we refer to the state's first count of this element of having to prove that the defendant had previously been convicted of a felony, I want you to recall yesterday when the defendant took the stand, he made that admission to you. He's told you on the stand that he, in fact, was a convicted felon. However, the state did not want you to just take his word for it that he was a convicted felon. That is why today we brought to you our latent print examiner, and she told you she made a comparison to the defendant's known prints and to this judgment and sentence, and it was the same person, the same defendant, Michael Monroe Banks, who was previously convicted of 2 felonies, aggravated battery on a pregnant female, and battery second or subsequent offense. And for this reason, now that you have this additional evidence, you have this additional certified copy of this prior conviction, and you have received testimony from our latent print examiner that this is the same person, and based on all the prior evidence, the state would ask for you to also find the defendant guilty of count 5 of being a felon in possession of a firearm. Thank you.
Any argument from the defense?
None, Your Honor.
All right, thank you. All right, you can now take those instructions, your separate verdict form, which Ash Bishop has, and go in the back and consider your verdict. Thank you.
All right, your next thing?
and pull the jurors.
State of Florida versus Michael Banks, case number 24CF817, trial division 2, verdict. The defendant is guilty of felon in possession of a firearm as charged. During the commission of the offense, did the defendant actually possess a firearm? Yes. So say we all, dated this 20th day of August, 2026, signed by the foreperson of the jury. Juror number 37, is this your true and correct verdict?
Yes.
Juror number 1, is this your true and correct verdict?
Yes.
Juror number 4, is this your true and correct verdict?
Yes.
Juror number 7, is this your true and correct verdict?
It is.
Juror number 8, is this your true and correct verdict?
Yes.
Juror number 11, is this your true and correct verdict?
Yes.
Juror number 18, is this your true and correct verdict?
Yes.
Juror number 19, is this your true and correct verdict?
Yes.
Juror number 23, is this your true and correct verdict?
Yes.
Juror number 26, is this your true and correct verdict?
Yes.
Juror number 31, is this your true and correct verdict?
Yes.
And juror number 32, is this your true and correct verdict?
Okay, so you've completed your jury service, and we got you done a day earlier than anticipated, okay? I can't begin to tell you how thankful and grateful I am that all of you honored your summons, that you all participated so extensively during jury selection on Monday, and that you were willing to step up and do what is a difficult but important constitutional duty. Like I told you all on Monday, the day we can't fulfill the promises we've made for 250 plus years, got to rename our country, okay? Because we've lived by that Constitution. It is what has kept us together. And you all always give me hope and promise for the future that we're going to keep on going. Because when I see citizens step up and perform these kinds of inconvenient and difficult, you hear things that I'm sure none of you would necessarily ever want to hear in your life. You sit so intently during a trial and take such good notes and pay such close attention. And then you go in the back, and 12 of you work together to come up with a unanimous verdict. Really is kind of remarkable. And all of you should be very proud of yourselves, proud of our systems, are proud of our country. Like I told you all on Monday, it doesn't matter whether you agree or disagree with things that are going on in our country now. At the end of the day, what unites us all is we're Americans, and we live in this country, and we live by a constitution and the laws of this country. And you've helped us carry this forward. You've given Mr. Banks a resolution. You've given the state of Florida and the victims in this case a resolution. And so it's with my greatest thanks on behalf of myself, the parties in the courtroom, all my fellow judges here on the 13th Judicial Circuit, that I'm going to discharge you from your service. So here's the deal. All those rules I imposed on you, they're now lifted. However, you don't have to ever talk about what took place during the deliberations on this case. But you can talk about it if you choose. You also can talk to lawyers and let them know what you thought of their presentations and what you would change if they do something over again. If you want to, they're not allowed to approach you, but you can call them up and discuss matters with them. I am always available to talk to any of you. As you can tell, this is what I've done for 38 years, and while it's been difficult, okay, it's been my love and my passion, okay, for 38 years. And it's soon about to come to a grinding halt. However, I am a big proponent of everything we do in our justice system, both on the civil side and on the criminal side. And if any of you ever want to discuss it or discuss anything that you have a question about pertaining to this case, you can always reach out to me. You can find me on the 13th Judicial Circuit and give me a phone call. I'm better with emails. Send me an email and I'll respond, because like I told you, I'm going to be in trial tomorrow and I'm going to be in trial next week. But if you send me an email, I will always respond, and I will always respond pretty quickly. So it's with my greatest thanks that I discharge you. I'm probably going to sentence Mr. Banks. If any of you want to see that sentencing, what you can all do is step out with Deputy Bishop. He'll walk you back in and you'll sit in the back in the courtroom if you want to watch the sentencing. If you don't want to stay for the sentencing, because maybe you got a glass of wine or a beer or God only knows what waiting for you at home, you can leave, but if you want to find out what happened later, once again, you can reach out to the deputy or you can email me and I'll let you know what happened. But thank you so much. I wish you all a great rest of your day, week, and year. Thank you so much. Take care.
Jurors next one?
Let me see what the reforms. And the first one. Oh, thank you. All right, the jury's left the courtroom. Everybody can be seated. Any reason why I shouldn't sentence Mr. Banks today? Okay. So, Mr. Banks, you know there's a lot of mandatory sentencing here, okay? Now, let me ask everybody, are there mandatory sentences for counts 2 through 4?
There are.
I mean, 2 through 5. Tell me what they are.
Okay. 2, 3, and 4 all have 25 to life.
Okay?
Or no, 25 to life on 2 and 3. On 4, it's discharge, mandatory life with the law enforcement answer.
Okay.
What about the 10-20 life? Is it 20 years?
Oh, do I have to do that too? Hold on for a second, let me write it down. So redundant, I mean, really.
It is.
All right, so count 1 is mandatory life.
Correct.
Count 2, the attempted first-degree murder with a firearm should be a life felony.
It's a life felony.
Okay, and that's 3 as well, and that's 4 as well, okay?
Correct.
All right, and so under 10-20 life, on counts 2 and 3, it's 25 to life?
Correct. And count 1. I know it doesn't matter, but if for some reason it came back as a second from the second DCA,
Okay,
we would have that, so we always seek it in honor.
all right. And then count 4 is mandatory life as well?
It is mandatory life.
For the law enforcement answer.
And then count 5 is a 3-year min-man?
Correct.
Correct. Count 4 also has a 10-20 life, 20-year mandatory for discharge.
20 for
20, yeah, I said 25? Yeah, 20.
Yeah, it's 20.
It's 20, correct.
And let me ask you this, so, okay, got it.
And Judge, apparently, Ms. Masiri just pointed out to me the 10-20 life law was amended recently, in the last couple of years, but the 10-20 life qualifying offenses must be sentenced consecutively, which I was not aware of that.
Sorry, say that again?
It
I've done a
requires-
lot of trials, Miss Masiri.
It requires consecutive sentencing.
Yes, Your Honor, this is a recent amendment within the last year, so if we were looking at the 10-20 life statute, 775-087, and we're looking now at subsection 2,
You guys want to look at it?
or 2D and E.
Judge, I'm gonna be honest with you, I'm not gonna be prepared to address that today, so if that's what they're seeking, then we should go ahead.
Is that a
and another-
mandatory?
It is.
Shall sentence?
It is, it's a shall sentence.
Okay, what statute number did you just tell me?
775-087, subsection 2, D and E.
D and E?
Correct.
What's the main section I can jump to?
775-087.
That's the main section.
Oh, 2,
Just wanna jump to that.
yes.
Where are you seeing this?
Under paragraph D.
Paragraph
D,
D?
as in Delta.
But more complicated. Is it retroactive? So if they're gonna seek that, I just wanna make sure that I'm dotting all my i's and crossing all my t's. Because this offense occurred back in 2024, January 2024.
That's what it says.
Judge, if the new death penalty law has been, the new death penalty sentencing statute has been determined to be a procedural rule that is retroactive, I don't know why this wouldn't qualify. It's a sentencing statute.
I agree.
Procedural.
A whole nother larger conversation, Judge. So, if the court wants to give us a sentencing date, I can prepare a memorandum once I've reviewed everything, if I feel
Sure.
differently.
Not a problem, so that's what I'm gonna go ahead and do. I'll give you a sentencing date. How long do you need?
Let's see. If the court has any availability at the end of September, not the week of the 28th, I'm sorry, maybe the week of the 21st if you're available.
The 21st is a holiday. I'm in a trial that week, but we can set it for the 25th in the morning at 8:30.
Okay, that would work for me.
And any memos or anything that you're gonna file, I would like to get by the 18th of September.
Yes, ma'am.
25 and 18 of September. Judge, there are two members of Ms. Muente's family. Would you be willing to hear from them today
Absolutely.
so they don't have to come back?
Yes.
Yeah. You wanna come up here? Yeah, just come up here. I know. Turn that on for you. I want you, if you can, state your name and your relationship.
Okay.
Good afternoon.
Good afternoon, Judge. My name is Roxana Bernales Muentes. Joe was my sister-in-law, and I'm actually reading this on behalf of her brother, Matthew Muentes Nesman, who is he's a sergeant first class in the U.S. Army. He wasn't able to be here, so he's asking me to read this.
Okay.
And I'm sorry if I'm emotional.
That's okay, not a problem. I'm sorry we're meeting like this.
Okay. And he's addressing this to you as if I'm him. He
Okay.
says, Your Honor, my name is Matthew Lee Nesman, formerly Matthew Lee Muentes, and I am the brother of Josephine Muentes, who was murdered on the 17th of January, 2024. Josephine, or who is better known as La Jo, was a determined, positive, outgoing, and supportive sister. Not only did she give me the strength and development that I needed while growing up, but also maintained her support throughout my life as an adult. She was very hardworking, loyal, determined, forgiving, and for me, had the heart larger than life, and will forever have been taken from not only me, but my family. La Jo was someone I could confide in, and we shared life impacting memorable moments of happiness, grief, and what it is like to be part of a family. La Jo contributed to the community in many ways. In my life, I have observed her throughout, directly supporting members of the community during hardships when others were unable. She would always go further to make sure that the people she helped were taken care of. She also was an anchor within our family that provided hope even in the most darkest of times. These traits of compassion, trust, and loyalty extended beyond me, my family, and poured into the community. Me, my family, and the city of Tampa, the state of Florida, and the world have lost a soul at the hands of Michael Monroe Banks. Michael Monroe Banks is an uncontrollable monster that was conceived in evil and manufactured on this planet to destroy the life of innocence. He is worthy of nothing short of life in prison or death and should no longer be considered a human, but a nuclear threat to all of humanity, the city of Tampa, state of Florida, and the world. I do not have it within me to forgive you or forgive him. What he has done to our family is not forgivable. Losing LaJoe has left a permanent hole in our family, and no amount of time will fill. The impact on me has been profound, and now I carry a heavy absence that includes me to no longer being able to turn to LaJoe for advice, laughter, support, or a shoulder to cry on. The future I imagined sharing with her is gone forever. As a senior member of the United States Army, and at the time of the murder, I was experiencing the most rewarding days of my life with the Army, who are also my family. LaJoe and I were planning for her to relocate to Los Angeles, California, where I was stationed. But that was immediately overshadowed by Michael Monroe Banks and his heinous evil actions. I have never experienced the level of evil that you have inflicted towards the family and the family of my Army. I will not assume to know the amount of suffering that the rest of my family has experienced and the emotional toll of our health, relationships, and our sense of safety in the world. It is unimaginable that beyond comprehension, my heart bleeds in pain whenever I see my surviving siblings and when I remember the carefree attitude of LaJoe's spirit. I ask the court to consider the full weight of this loss when determining the appropriate sentence. LaJoe, Josephine, deserved a full life. We, her family, the community, and friends will carry this loss for the rest of our lives. Thank you for the opportunity to be heard. Respectfully, Matthew Lee Mesman, United States soldier.
Thank you so much, and thank him.
Thank you.
Judge, I believe Ms. Fuentes' cousin wants to be heard.
Okay.
Thank you. Good afternoon, Your
Good
Honor.
afternoon.
My name is Teresa Calderon. Thank you for allowing me to speak.
Always.
I do appreciate it. I will apologize in advance because, as you can imagine, this is very difficult. I also have asthma, so I'm praying that it doesn't flare up. Josephine Fuentes was my cousin. She was not only my cousin, she was more like my sister. We were attached at the hip. Josephine and I were the same age. Our birthdays were a little over a month apart, almost exactly to the day. When I tell you she was like my sister, it's because we grew up together. She lived in my house throughout the years. All of the important moments in my life were shared with her, not as my cousin, but as a sister. As we grew up and became adults, people often saw us and thought that we were really sisters, and that's how we remained. January 17th, 2024 is a day that I will never forget. A day that changed my life completely. It not only changed my family's life, her brothers and sisters' lives, but it really changed my life. My best friend, my sidekick, my cousin, my sister is no longer with me. I had to celebrate my birthday by myself without her. Josephine and I had a bucket list. We had our own version of our bucket list. And we told ourselves we wanted to go to several concerts together. There were certain things we wanted to do, but when we turned 55, we were outside the box thinkers. We didn't want the traditional 40th or 50th birthday, 60. We wanted 55. And that was this year. I struggled for my birthday a month ago because she was not here. I could not share that moment that we so much talked about and planned. And her birthday is in the next couple of weeks. And I'm struggling thinking about the fact that she will be 55 and she's not on this earth with us because some individual decided to take her life. Josephine was a wonderful woman. She was sassy. She was a short little person like me, but she was sassy. But she was such a good-hearted person. If you needed help, she would help you. She would take the shirt off her back for you, not knowing you, but she would help you. She had compassion and love. And knowing her the way I knew her, I can almost put my life on it to say that she wanted to help Michaela. She was good friends with Norma. I know who Norma is. We know her. And I know my cousin enough to know that she was saying, we need to get her out of this situation into a safe place. If that's what cost her her life, she died a hero. I'm proud of her because that's the Josephine that I knew. Many knew her by Josie. My name with her was La Negra because she was always more tan than I was, and it was always like a little inside joke. I will never be able to say hello to her again, goodbye. I will never be able to pick up a phone, text her, and share all the good things that I'm doing in life. I have to remind myself to push myself to do better because that's what she would want. We even got matching tattoos. We come from a big military family. I was also in the Army. And I remember when I first moved to Florida, I got a job at Walmart with her. I picked up the same shift. We did everything together. And she pushed me and she said, let's go get a tattoo. We got the same matching tattoos on the same side of our shoulder. And that's a reminder. The day that she was murdered, yesterday was the first time I was able to see all the pictures and really get a full account of what happened because my family, they love us so much that they wanted to protect me by omitting certain information. So this was a big surprise to me yesterday. Haven't slept much thinking about this. And from the day I got the news that my cousin was killed, I thought about what I would say, what I would do, how I would feel the day I saw Michael Monroe Banks face to face. All I can say is that he's a coward. He was wrong. And he deserves to be punished for what he did. He had no right at all to put that gun to my cousin's head and take her life. She did nothing wrong to him. She did the one thing that he stood up here yesterday and said he was trying to do, and that was to protect his daughter. He stood up here and said that he was trying to protect his daughter. My cousin wanted to protect her with his mother, and he decided to take her life. He made that choice. He had a choice to make, and he chose to take her life. He needs to be held accountable. Not once in any of the testimony did I see or feel any remorse from him whatsoever. He had ample opportunities to at least stand up there and say, I'm sorry for what I did. I did not hear that. Unless I missed it, I did not hear it one time. That's what's really hurting me even more because there was no remorse behind what he did. That tells me that he meant it. He wanted to kill her, and he did. At least his mom is still here. His daughter is still alive. Yes, they are scarred, and they will be traumatized for the rest of their lives. But Josephine is not here. I will never see her again, only through a picture, through me closing my eyes and shuffling up memories. But I don't know if I can move on. I'm trying my best. It's been 2 years, Your Honor. Everywhere I look, it's a reminder of my cousin. When I moved to Florida, I moved here 24 years ago. Like I said, I came out of the military. She showed me Tampa. She took me to every restaurant, every coffee shop, any and every place I go to in the state of Florida. It's something I shared with my cousin. I don't have that. When I go out to eat with my husband, I cry so many times because it's a reminder I sat in the same place with my cousin. She was the first one to bring me to this restaurant. When I hear a song, I break down because we spent countless days, hours in her vehicle, my vehicle, going to the beach, going out, and we would turn on the radio and sing songs. We always had nicknames. One of her many nicknames for me was La Secre, which means the secretary. She considered me her secretary because I was in charge of everything. One of her other nicknames for me was Buttercup. And I thought about that yesterday as I sat here listening to Michael speak. I'll never hear her say that to me. Come here, Buttercup, Buttercup. I'll never hear her say that to me. Every Mother's Day, she made sure I had the best Mother's Day. She made sure I had the best birthday. She believed in anything and everything I wanted to do. I started my small business during COVID, and when I went to her with my idea, she never told me it was stupid. She encouraged me. She told me she was proud of me. I will never hear her say those words, to me again. So the loss of Josephine goes a lot deeper. There was a community that loved her. There was a family that loved her, friends, loved ones. She touched the lives of many. I can only speak for myself when I tell you that I feel that emptiness. I really do. And I think it's because we were, like I said, so much alike. We were the same height, everything. And our birthdays were almost to the day, like I mentioned earlier. How do you tell somebody, move on and pretend like it didn't happen? I don't have a light switch. I can't turn it on and off. And I really am trying, but my house, when I look at my house, she spent most of her time in my house, my living room, my kitchen. And when I'm there every day, I can't help but cry. Sometimes I have to go into my bathroom and cry and wash my face and come out because I don't want my daughter to see me crying. I can only be so strong, and I'm asking you to please, when you do your sentencing, please consider everything that we have said. Everyone in this room has someone in their life that they love and love dearly. And if you were in my shoes, you would want that justice. You would want something to be done. If I was not standing here right now and Josephine was in my place, she would push hard so that justice would be done for me. And that's what I would like for her. That's the least that I can do for her. To finish what I want to say, she really had no idea that on January 17, 2024, she was going to wake up and that would be the last day that she was going to be on this earth. All she wanted was a cup of coffee. The damn cup of coffee that she never got to drink. The cup of coffee that never made it to her lips. Because Michael Banks decided to put a gun to the side of her head and pull that trigger. That is an image that I can never take away from my brain. I wish it didn't have to happen that way, but it did, and I can't change that. Moving forward, all I want to try to do is be there and be the... My cousin, I don't know if this was stated or not, but Josephine had lung cancer and she beat that recently, prior to her being murdered. As a family, do you know how hard it was to see her going to the chemo? I was there with her, her siblings were there, we were all there as a family, so we were overjoyed to know that she was in remission and she had beat that cancer. just to shortly after be murdered and taken from us. If she would have passed away from cancer, I believe we would have mourned her, but it would have been easier for us to say, you know what, her illness took her. Not some monster who made it his choice to take her life away from us. He had no right. And that is where the struggle comes in for the rest of us. She was an innocent bystander. She did nothing wrong but to wake up that day and desire that cup of coffee. I thought about the consequences of everything that happens, and Michael Banks doesn't realize exactly what he did. Maybe he does. I'm going to say he doesn't. After my cousin was murdered and her siblings went to the house to pick up her belongings, they called the family together and said, hey, come over. You can go through her stuff. If somebody would like something for a keepsake, take it. Because my cousin and I were so close, we had matching watches. We had a lot of things together, her and I. I asked about it. They said, we can't find it. When I saw that picture on the screen yesterday, and the doctor was explaining those earrings that she had that day that he killed her are the ones that I have. That's all I have of her. That is the only thing I have. I remember my cousin gave me a bottle of fabric softener, like a big jug. She said, take it, you know. I brought it home, and